coming? Oh, here he is. Here's Kevin, as you. Okay, so the chairman has asked me until we formally appoint our acting secretary. I'm going to do this like we'd be at a reorg meeting. So I'm going to announce that this is the Raritan Township Board of Adjustment regular meeting of June 16, 2022. The meeting will be conducted in person at the municipal building with an option to participate virtually. And then there's instructions on the agenda how to attend virtually, which makes no sense for me to read them because if someone would have had to read them beforehand to participate virtually. So I'm going to call the meeting to order, and I'm going to read the notice requirements of the Open Public Meetings Act have been satisfied by placing of a notice of this meeting on the bulletin board at the municipal building, filing same with the township clerk, and transmitting same to the Hunterdon County Democrat, the Courier News, the Star Ledger, and the Trenton Times. And I am going to call the roll. Board member Kevin Cool. Kevin, you've been called. Kevin, yes. Board member Cynthia Schaefer.
Here.
Board member Randy Block.
Here.
Board member Steve Farcio. Anyone here from Steve? So for now, he's absent. If someone could contact Steve, you could always give him an excused absence at the next meeting for this meeting, but right now we have no
He's on.
request for an
He just
excuse.
joined.
He just joined?
I'm admitting him now. Yep.
Ah, great. Well, Steve's coming in. How about Chairman Roger Aaron's,
Yes, here.
Jim Ferraro,
Here.
Brad Perry,
Here.
Bill Cummins,
Here.
and Rasul Damji.
Here.
Okay, I am here. Tony Hajar,
Here.
Jeff Vaccarella,
Here.
Jessica Caldwell. Okay, so can you please, can you spell your last name slowly? Okay, and you're from Jessica's office? Okay. John Thomas. Charlie Hecht is excused. Jay Troutman, excused. And our board stenographer, Jackie Clapp. Ah, and there we go. Look at that. Steve, board member Steve Farcio, are you here?
I am here.
Wonderful thing. Okay. Do we have any comments? Nope. Do we have any announcements? Do we have any distribution and correspondence other than on a pending application? No. Okay, so the board has an appointment, as everyone's aware. Amy, our board secretary, has left for greener pastures, and we have a proposed resolution. Can I see the resolution, please? Want to read the resolution into the record and ask if there's a motion, a resolution appointing an acting board secretary for 2022. Whereas there exists a need for secretarial services for the board, and the municipal land use law, specifically NJSA 40:55D-69 and 71B, provides that the board may elect a secretary who need not be a member of the board and employ such staff as it shall deem necessary. That was a side comment to Tony. Whereas the board determined that Lisa, is it pronounced? Thania should be appointed as acting secretary for the board. Now therefore be it resolved by the Raritan Township Board of Adjustment on June 16, 2022 as follows. Number one, Lisa Thania is hereby appointed as acting secretary for the board for the year 2022 for the purpose of providing secretarial services to the board during all board meetings, which services include but are not limited to providing for the verbatim recording of all public portions of board meetings by audio tape means, signing true copies of all resolutions adopted by the board and all site plans and subdivision plats approved by the board once all conditions of approval have been satisfied. Number two, the board secretary shall be it will be the board acting secretary. I'm going to mark this up and give it to you guys. Shall be compensated in accordance with arrangements to be made between her and the township. And then number three, a notice of this resolution shall be published in an official newspaper of the township in accordance with the local public contracts law. Someone want to make a motion to adopt this resolution?
So
Second.
I'll second.
Who made the motion? Our chairman, Roger
I got it.
Aaron's made the motion, and Mr. Ferraro seconded it.
Mhm, got it.
So I'm going to do a roll call. 7, we have 7 regular members. Cool.
Yes.
Schaefer,
Yes.
Block,
Yes.
Farcio.
Yes.
Yes, correct?
Yes.
I thought he said here. Aaron's,
Yes.
Ferraro,
Yes.
and Perry.
Yes.
Okay, I'm now going to hand the meeting over to our new acting secretary, Lisa Spania.
Hello.
All right. Next item on the agenda is minutes. And we have the minutes of the May 19th meeting. I have a couple of just quick correction. It says page 2 of 5, page 3 of 5, page 4 of 5. It actually should be 2 of 4, 3 of 4, 4 of 4. And then we have, are there any other corrections or additions to the minutes? Can I have a motion to accept?
I'll
the
make a
May-
motion to accept the minutes of May 19,
Thank you.
2022.
I second Randy Block.
Lisa?
Mr. Chairman, Roger Aaron's.
Yes.
Vice Chair, Mr. Kevin Cool.
Yes.
Chair Pro Temp, Ms. Cynthia Schaefer.
Yes.
Mr. Steve Farcio.
Yes.
Mr. Randy Block.
Yes.
Mr. James Ferrero.
Yes.
Mr. Bradford Perry.
Yes.
Okay, we also have the minutes of the June 2nd meeting. And I note one minor correction on that on page 5 of 6. Down in the third paragraph from the bottom. About the middle of the paragraph, it reads, "The property is in the B2 zone. It should be the O2 zone." And then further down, it says, the structure was built prior to the O2 zone. That is correct. So with that change, can I have a motion?
I'll make a motion to approve the meeting minutes of June 2nd, 2022.
I second it, Randy Block.
Thank you. Lisa?
Chairman, Mr. Roger Aaron's.
Yes.
Vice Chairman, Mr. Kevin Cool.
Yes.
Chair Pro Temp, Ms. Cynthia Schaefer.
Yes.
Mr. Steve Farcio.
Yes.
Mr. Randy Block.
Yes.
Mr. James Ferrero.
Yes.
Mr. Bradford Perry.
Yes.
Okay, we have no resolutions tonight, so I'm going to call our first application, which is BOA case 35-2021. The applicant is James Radigan. The location is Block 76, Lot 5.01, 21 Forest Drive. The application is for a C variance structure within the preservation of natural resources buffer, natural features buffer, excuse me. Mr. Radigan, I understand you're recommended, or you're represented by counsel tonight.
Good friend and long time associate.
Can you enter your appearance on the record, please?
Yes, Kenneth Glynn for applicants.
Can you spell your last name?
Glyn.
Okay, so where we left off, this hearing was opened and we got most of the way through. The date was I believe April 21st. Is that what your records reflect?
Yes, sir.
Okay, and you were sworn at that time and you
Yes.
gave testimony.
Yes.
And I believe the only remaining issue in Tony and Jeff's report, this is their report dated March 31, 2022, was your application was for an apartment in the basement, correct?
Correct.
But it was a D3 variance. It wasn't a D1 use variance because in the zone, it allows accessory apartments. And there was a bunch of back and forth on the size, but the board eventually decided that, yeah, You complied with the size.
Thank
And the only remaining issue was the item 5, which was the ordinance says adequate provisions shall be made for water supply and disposal of sewage. I'm reading from his the item 5 in their memo. Actually, it's item 1, number 5. The on-site sewage disposal plan and well water sufficiency and potability must be approved by the county health department and/or the RTMUA. Now, as I understand it, you apply to the Hunterdon County Health Department, and in fact, you have an approval. And I'm looking at the approval, which was received, you signed it on April 11, 2022.
Monday.
Okay, you signed it on April 11, 2022. It was approved on June 9, 2022. And it was then that day sent in to the planning department on June 9, 2022. My understanding, and I'm going to ask Tony, I'm just setting this thing up so you understand at least my view of the situation. You applied on the form that you signed, you said that the proposed renovations to my home, you're supposed to circle one, will not. We assume you meant to circle will not, even though you didn't circle one. So I'm going to assume it's will not result in an expansion of the potential number of bedrooms in my home. My house currently has, and you wrote in 4
Correct.
bedrooms. At the completion of the proposed construction, the house will have 4 bedrooms.
Should have been well now.
And the way you got it down to 4 bedrooms was you submitted a plan which removed one of the bedrooms on the second floor and indicated that it's a storage room.
It's more, it's an office storage room combination. There's a step down, it's got heating, it's not really.
It says on the plan, storage,
Yes, sir.
okay? And so the position that you're taking is you have 4 bedrooms because you eliminated what would have been the 4th bedroom in the house by calling it storage, but you have this apartment in the basement. The township engineer and board engineering expert's position is that that apartment in the basement is not a bedroom, it's an apartment. Because of that, you don't have approval by the county health department for septic for that. So I want Tony to explain, he's done a calculation. I asked him to, when he first told this to me, quite frankly, I couldn't understand what he was talking about. Because if you take out a bedroom and call it storage, and then you have something in the basement, I looked at it as like, oh, you had 4, and the accessory apartment with 5, you took out 1, 3 + 1 is 4. But it's not, because it's not a bedroom, and I believe he's correct, but explain, Tony, please.
Okay, so the number of bedroom is,
What you're reading from what?
I'm reading for NJAC 7:9, A-7.4.
Okay, so that, if it's NJAC 7, that's an NJDEP regulation.
That's correct.
And if it's in 9A, that's for septic.
Yes.
And so what's the title of,
Volume of sanitary sewage.
okay, what does it say?
It says the daily volume for each bedroom or dwelling unit shall be, volume for the first bedroom is 200. Volume
Whoa, whoa, whoa,
for each,
the volume 200 what?
200 gallons per day.
Okay, for the first,
First bedroom,
okay,
volume, each additional bedroom is 150 gallons per day.
okay, so the position you're taking is that first bedroom
It's 200.
is 200, so bedroom 2 and 3 are 150 each for a total of 300. Is that correct?
That's correct.
And then,
Total would be 500 for that dwelling.
okay, and then,
And then it talks about minimum volume per dwelling unit is 350, and also mentions minimum volume per apartment is 350.
okay, so your position is that you take the 500 and you don't simply add 150 to it. You have to add 350 to it because that's what the reg says. And so instead of being at 650 gallons per day, he's at 850 gallons per day. And his approval is only for 4 bedrooms, not for 3 bedrooms and an apartment.
That's correct.
So you can say, let's hear your position, but it sounds like to me that he's got to qualify. In other words, if you qualify, we told him he doesn't need a D3 variance for that apartment if he can qualify with this last requirement.
Right.
Now, if he doesn't qualify, he's going to have to explain to the board why they should grant a D3 variance when all he'd have to do is go back there and presumably get them to up the gallonage by 150 gallons.
Right.
So,
Well,
like 200. So go ahead.
yes, I'm obviously new to this situation, but I did spend,
You,
sorry.
you got to go right
Is the
close
mic
to
on?
that mic.
Yes,
can
I'm
take
sorry.
that.
There you go.
You can remove it. if
No,
you
no,
want.
So-
no, this is good. This is
I'm
good.
okay. So I'm obviously new to this situation, but I did spend 3 hours today, part of the time on the phone with Jim Hill, part of the time reviewing a submission by Mr. Hill to the Board of Health and going through the files and meeting with my client. And if I can phrase the issue a little differently, I believe what the engineer is saying is
Hey,
that,
hold on. Where's the engineer?
I'm sorry.
Oh, well, Tony, I thought you meant Jim Hill.
No.
Oh, okay, okay.
Uh,
You believe what?
May I refer to him as
Call him
Tony?
Tony, yeah.
Tony, okay. So I think that the part of the information that you should have is that this house was built as a single-family, 4-bedroom home in 1987. At that time, they didn't measure by gallons per day. They did calculations for a septic in a field, and they defined the field by the length of pipes in the field for drainage. And under today's standards, they go by gallons per day.
Right.
And so there has to be a conversion
Well,
from,
what do you mean it has to be a conversion? Why
Well-
wouldn't the current regulations apply since he's now applying for apartment?
yes, but if you accept those, I have 2 or 3 different arguments. The first one is to start with the premise that if you accept those,
Right?
then when you look at the gallonage, you have to calculate how many feet of field would accommodate that. So the question becomes,
Okay, where does it say that in the regs that you calculate how much feet in the field accommodated?
the old system has,
Listen,
based on,
that's between you and the Board of Health. That's not their issue. They're not going to make a decision on whether there's sufficient capacity. What the ordinance says is get them an approval. You get the approval from the Board of Health, boom, you're in. If you don't get the approval, you need relief from them.
okay, but, okay, I'll approach it differently. The issue of determining the total gallonage by adding the numbers the way it was done by Tony comes up with a very disproportionate number. I didn't write down the exact numbers just now, but if you have 300 for,
I can tell you what it is.
sure,
If he had 4 bedrooms
right,
and not 3 bedrooms and an apartment, then the calculation would be 200 GPD for the first bedroom, 150 for the next 3 bedrooms. So that would be 450 plus the 200 would be 650 gallons per day. And that's what I interpret the Board of Health approval for. But he doesn't have 4 bedrooms. He has 3 bedrooms plus an apartment.
Yep.
The way the calculation would go is 200 gallons per day for the first bedroom, 150 gallons per day for the next 2 bedrooms, which is 300. That is 500 gallons per day plus for that apartment. Under the regs, it's 350, so it's 850 gallons per day. So because of the way those regs are written from the DEP, he needs 850 gallons per day, not 650 gallons per day, if he wants to meet the requirement of that conditional use ordinance for the accessory apartment. It's a
Yeah.
very simple calculation for the board. In fact, they don't have to calculate anything. All they have to do is say, go to the Board of Health, resubmit the application instead of 4 bedrooms, 3 bedrooms plus an apartment, submit the approval. If you submit that approval, boom, he's in. He doesn't need any relief for the accessory apartment. All he needs is the relief for the deck, which I believe they also kind of worked out because he got a zoning permit a long time ago. Basically, they're going to say, what are we going to do? Make him move the deck? He got a zoning permit for it.
right.
So he is like on the 1 yard line.
Well, Okay, what I
And I
have.
don't know what the board can do
Yeah,
for
what
you.
I have the benefit of that got me started maybe in the wrong direction with everyone because the rest of you haven't seen this yet. Is that Jim
Now, you
Hill
didn't hear the beginning.
today?
What you said is what you have the benefit of.
Yes, what I have the benefit of is calculations that Jim Hill did today to convert the gallonage into lineage. And I won't go over those numbers again, but his conclusion in the letter to the Board of Health today was that Jim Radigan's system, as it sits today, will handle the gallonage that's required for an
And
apartment.
guess what? I guarantee this board hopes that the Board of Health agrees, because then it takes this issue away from them.
Right, right.
Okay, but that's between what my advice and opinion is, that's between Mr. Radican and the Board of Health, not Mr. Radican and the Board of Adjustment.
Okay, so you pointed out correctly that the only issue remaining is this issue. And if you would go back in time to the time the house was built, it was built as a four-bedroom, single family. Back in that time, life was simple. A single family was a mother and a father and children.
Right.
And if you have the mother and father in one bedroom and you're buying a four-bedroom house, you have perhaps 3 or 4 or 5 children. So this house was built for, on average, say 6 people. And back then it was required to be whacked up by 50% above the calculated capacity for that kind of household. Today, Mr. Radigan has one of the 4 original bedrooms designated as storage.
Yeah, by the way, just to give you a heads up about that, they're going to want a deed restriction, that room is going to be deed restricted to storage. Otherwise, if there's no deed restriction.
Jeff, explain.
Well,
Okay, so if you want them to give a zoning permit
right.
for the conditional use accessory apartment,
Yeah.
you not only need to think from the Board of Health, but you're gonna have to present the deed restriction
Yeah.
that room has to be, it cannot be a bedroom.
I take
That's the
care of
better
that.
way
I
to say it.
saw
Thank you.
that in the deed.
Yeah, Jim. You're right. The first time you said it, I was going to say, I disagree. It shouldn't be limited to storage, but the deed has to say it can't be a bedroom.
Correct.
So back to my point, it was a 4-bedroom then, it's a 4-bedroom now.
It's not a
By-
4-bedroom
by-
now.
By calcul,
It's a 3-bedroom and an apartment. It's not a
Well,
4-bedroom.
but if you start with it, the basement is an apartment, I understand, and that's what the application starts with. But if you look at what we're asking the board to do, we're saying it's less than an apartment. It's an
Can I ask you something?
in-laws.
What do you want the board
We
to do
want the
tonight?
board to restrict us to an in-law suite with only one occupant, with that occupant being a family member and
And if you want
granting
the
us-
board to do something tonight, that means you're still seeking the D3 conditional use variance because you don't comply with the septic thing.
At this time, yes.
So what's your argument to the board to grant that D3 variance tonight?
Yes,
What's the
the
argument?
argument is simple. That we're talking about Mr. Radigan's father. If he wasn't living in the basement, he'd be living in what is now the storage room and what will be designated as a non-bedroom room. He's going to use the same amount of water, whether he uses the first floor sink or the basement sink. He's going to use have the same toilet usage, whether he's on the second floor, the first
What's
floor
the
of the
special
basement.
reason under the statute that they should grant relief when all you'd have to do is go to the Board of Health and get them to acknowledge that his septic can accommodate the 3 bedrooms in the apartment, which you say, Jim Hill says can be done? What's the special reason that they're supposed to find to grant a D3 variance rather than have you comply?
Because, well, I'm not Jim Hill. I can't
Well,
testify.
That's
And
unfortunate.
someone may very well disagree with them, and I think there might be a difference of interpretation of how you add up the gallonage. So I'm trying to play it safe. I came in the middle of this process, and I would like to see Mr. Radigan, and he would like to get the variance tonight if possible.
Again, what's
And
the special reason? They can't just grant variances because they
No,
like
the
Mr. Radigan.
special reason is that he has an 88-year-old father, and we
Okay.
want severe
Right,
restrictions
and
on.
he's living there right now in the
Yes,
apartment, right?
yes,
No one from the township is asking to evict him,
that's
right?
correct.
Okay, so explain why would they want to grant a D3 variance when his father's in the apartment, no one's asking him to leave, and you just stated that your own engineer says that you can get to the Board of Health and show them that the system will accommodate it. What possible reason then would you give them to grant the D3 variance tonight with those facts that you just put on the record?
I mean,
Expediency,
be-
that's not a special
be-
reason.
because my understanding is that he should have the choice. And he
A
can,
choice of what?
of going back and satisfying the Board of Health or asking
Okay.
for this variance tonight.
Tell you what, you
And-
want to vote on the D3 variance tonight?
Well, I'd like to be heard first. I'm not
Okay, why
finished.
don't you make the argument? If he wants to vote on the D3 variance, then you guys can deliberate and vote on whether he's approved the relief for D3 variance. You go ahead.
Yeah, okay, thank you, I'm sorry. So the situation is that Mr. Radigan has a father who lives in the house. We're looking for very severe restrictions on this grant. We're not asking for a variance for an apartment per se. An apartment per se would involve
You're
perhaps.
not asking for an apartment per se because you didn't apply for that. That would be a D1 variance. The application is for an accessory apartment. That's
Yes.
what the application's for.
Yes, but we want to have an accessory apartment approved with some pretty severe limitations. And the result will be that although it'll still be called an accessory apartment because of the limitations,
Okay,
it's
give us your
actually
limitations. What limitations do you want to put on it?
that it be restricted to a single person, and that person has to be a family member.
Okay, let me ask you something. If this board restricted it to a single person without you offering up, do you think that would be a legal condition? In other words, if the board said, we'd like to restrict it to a single person, he can't be married and he can't have, a partner or anything in there. And you guys didn't propose that. They thought of that and they said, that's the only way we're granting you the variance. And you said, you went to court and said to the prerogative writ judge, that condition's illegal. What do you think the judge would say?
That's a hypothetical that doesn't
Oh,
apply. We're
I
the
can
ones
tell you
who
what
are
the judge is
asking
gonna say.
for
It's
it.
an illegal condition, but you're proposing to have it restricted to a single person
Yes,
where they normally wouldn't be able to do that otherwise. And you're gonna have, and he's gonna stipulate on the record that he forfeits his right to appeal from the imposition of that condition, and that's gonna be a deed restriction in perpetuity. And he'd agree to that?
that's my understanding from discussions today. Is that,
Okay,
is
then
that
if
still
you
the
go
case,
sell the
Jim?
property, that's not an accessory apartment down there. It's restricted to a single person. And what are the other restrictions? Maybe you have some, maybe he's gonna come up with a special reason, but let's see. I don't know if if your client's gonna like it, but what are your other restrictions?
That it be a family member.
Okay, what else?
Those are the restrictions.
Okay, and
that we're
that no one that he's not allowed to accept rent, either money or in-kind services from anyone.
We don't do that now.
Now, I understand, but when you go to sell the property,
Right.
the person who's gonna buy is gonna wanna know. There's
Right.
gonna be deed restrictions. When you go to sell the property, this variance, if you really want them to vote on it, assuming that they want to grant it, I don't know, they might deny it.
Right, they deny it, I'll simply do what you said. and
Correct,
go-
but if they grant it with these restrictions that are gonna be deed restrictions, then they're gonna be on. And then if you go sell the property and and you market it as, hey, I got 3 bedrooms, plus I got an apartment in the basement, and they're gonna find out the only person that could be in that apartment in the basement is a single person, a family member, and the owner can't get any rent in money or in-kind services. That's that's the restriction that might impact your marketability. I'm just saying, go in with your eyes open.
Well, you're analyzing it well. I'd be curious what you see as the alternative is.
I know the alternative is so easy. Go to the Board of Health, 3 bedrooms, accessory apartment. You don't need their approval. Then
As long as as long as we qualify.
yeah, but your attorney just said he spoke to Jim Hill, and Jim Hill said you're gonna qualify.
But I haven't
I'm
finished.
Talking to Dan on a regular basis, and I think they came up with the right figures, but I don't know that
Yeah.
because he couldn't do it in time tonight.
Yeah, I mean,
He-
Counselor, you're making it sound like it's horrible, but if someone bought this house, they couldn't have an apartment and rent out anyway. It's not allowed.
Okay, but they
So-
could do it to someone, they could have someone who was not a single person in there,
And
right?
if they want to do that, they have to come back here for a variance, I
Yeah,
guess,
I
right?
get it.
No. The deed restriction, these guys can't grant relief from a deed restriction. They can only grant relief from an ordinance.
Okay. So, may I continue?
Yeah.
Okay, so in my conversation with Jim Hill today, He made these calculations that sounded correct, and they were based on linear footage of the field. He calculated that you need 351 feet to comply with the statute, the rules, and we have 360 feet. After hearing what Tony said today, it sounds like the numbers are different, and we may end up not getting approval because of the differences of our engineer versus your engineer in terms of how that's calculated. On top of that,
Let's stop for 1 second. Does the Board of Health, are you the Board of Health engineer?
No.
Who's the Board of Health engineer?
I don't think they have.
Do they ever ask you your opinion on something like this?
No.
So if Jim and Tony don't agree, if you go to the Board of Health, it's irrelevant what his opinion is,
all right,
not to, you know,
we're here today in this conundrum with Jim Hill, from what I understand, because Tony raised this issue,
and what's the conundrum?
that what you're creating now, that Tony has nothing to do with the Board of Health, and yet the Board of Health is where you're saying we have to go back to.
Right,
And the Board of Health is what Jim Hill says he has to satisfy because of the issue that Tony raised
Right.
this week.
correct.
So
They
if I,
need to go to the Hunterdon County Health Department.
Yeah, it's not the Board of Health, I'm sorry. It's the Hunterdon County Health Department
the
because
Health Department, I'm sorry,
they approved for 4 bedrooms.
right,
What Tony, in my opinion, is that he does not have a 4-bedroom. He has a 3-bedroom with an apartment. That's our opinion to the board.
See, I thought it
So-
was a 3-bedroom with an accommodation for a family member in the basement. Let me just finish and you can tell me no. Who would be upstairs using bathroom, the kitchen, same things he's using downstairs, only, I mean, upstairs.
Is there a bathroom in the basement?
Yes,
Listen,
okay.
your application asks for an accessory apartment in the basement.
But I don't know why, I thought it was just an accommodation, but you're saying it's an apartment.
That's what it said. That's what your own application
That's what the
says, that you
application
filed with
says.
this board.
yes. Jim, let me finish. So, may I?
Mhm.
So we have this situation where I feel that based on what I heard tonight and what I saw this afternoon, that there may well be differences between the two. Now, here's the special situation that arises. Because of the property and the way it's set up and the way the size, the slope, where the septic system is, I was told by Jim Hill today that if we have to extend this field, we won't be able to do it. So we need this variance for that reason. And we're willing to go with these restrictions and put a deed restriction in. So we would ask you to vote on this, but with the understanding that even though legally and technically it is an apartment, with these restrictions, it's not going to put any additional load on the systems. In other words, the septic pipes don't care whether his dad's water comes from the second floor, the first floor, or the basement. It's the same one person doing the same thing he's doing, whether he does it on the first floor, second floor, or
Well,
basement. So
can I ask you this? That's what we were just saying. Does he need an apartment?
He
Can he
can't-
live on the main
He
floor?
can't do the steps up there. He would have to be on the second floor.
He's-
There's no way he can do those steps.
he's
No way.
88 years
The
old.
way I have it set up in the back, when he gets out, he has these long planes.
So
and
you
steps.
need an accessory apartment. In other words, he can't use the bathroom upstairs because he can't get up the stairs.
Well, no, he can use the bathroom, but he'd have to stay upstairs indefinitely.
I understand, but, okay, listen. Finish making your argument. The pitch is that if you granted the D3 variance, correct me if I'm wrong, you could get some restrictions that if you tried it yourself, like it's restricted to a single person.
Yes,
I would be telling you, yeah,
okay.
okay, but, so that's something you get now. The only other issue you have is that it's when that's a factor you could consider, but you also have the negative criterion to consider. And what's the purpose? You're going to have to think, what's the purpose of this ordinance provision? If the purpose is to make sure that there is going to be adequate sewage disposal. And now the attorney is now adding another, before he said, Jim Hill said it's not going to be a problem. Now he's saying it might be a problem. And if he's got to expand his leach field, that he's not going to be able to do it. So now that's a negative criterion thing that I don't even want to talk about, but
Yes, but what we are saying is that it was filed as an accessory apartment application. And you can call it that because that's what it is legally, but de facto, in reality, it's a one-person situation where he would be entitled to do the same thing upstairs.
right.
But for his age and his incapacity, and but for the land restrictions on the property being unable to extend the field, our path of least resistance would ask the board to approve this variance and in the process, understand that we're not adding any capacity in reality.
Can I say something?
Yeah, I got one more question for you. Have you considered, you could do some sort of handicap elevator? I mean, a lot of people,
Well, yeah, but then we wouldn't have autonomy. You know, I love my stepdad, but I don't want to live with it. I already got my son there, and that's bad enough. And I love him.
okay.
All
right,
Can I
all
just say something? And I'm not,
I'm just trying to think of ways to go around it.
I'm
Yeah.
not saying anything about experts. But everyone I talked to said.
Talking to that
everyone I
microphone.
talked
Come
to-
on, Jim.
No. You just pull that microphone, the table mic, pull it up to your face. You got a table mic, you see it?
Oh, there it is.
Okay, I'll be brief. Everyone I've talked to, and again, I'm not saying anything about the experts, say there's basically no difference between an accommodation in the basement for one person and him coming upstairs and using the same accommodations. Not only that, but the septic absolutely will do well. I mean, I've had him, it's been going on for 4 years and there's never been a problem. That's why I came up with a possible, with Ken, I came up with a possible negotiation. Even to the point where, since I clean my septic once a year, because I don't want to get hit with a $50,000 bill in the future, you may want to have a deed restriction that says, oh, in this particular house has to clean his septic once a year. But they're all telling me, either in private, off the books, or on the books, that my septic is very adequate for what I'm asking for. That's all I wanted to say.
Would you guys propose to them a further restriction, deed restriction that says, after eventually your stepfather is going to pass away, unfortunately, everyone does.
But then what do
Just
I-
listen,
I
once
know.
he passes away,
Right.
no more accessory apartment in the basement.
But then what do I do with the stuff down there? Jeff says, oh, you gotta take out the whole kitchen. Oh, so now I gotta, what do I have? It's like being in a fire and your face is destroyed. I mean, I really take pride in my house, and if you saw it, they can tell you. It's. a
I
house
take
of
it the
garden.
answer is you would not be willing to offer up a
No,
restriction.
that seems, to
No,
me, that
but
seems
with,
radical.
but with the restrictions, he would have to sell the house, disclosing these restrictions, and the
Right,
best,
but he's not willing
the
to have a
best someone,
restriction that the apartment would only be for his stepdad. And after, if the stepdad is no longer living there, the apartment has to be removed. He's not willing to do that.
You know,
no,
you know-
why should the township care whether it's Jim and his father or the next buyer and her mother? What difference does it make?
Yeah,
We don't agree with it.
I've already spent 10 grand coming here and I don't have any approvals, and I spent, money on getting my stepdad in there. I had no choice. He has Alzheimer's.
Well, in any event, for these reasons, that's why we're asking the board to vote on this, and we're asking you to recognize that in reality, what goes through those septic pipes won't change, whether we're forced to put the father upstairs or we keep him downstairs based on your approval. As an in-law suite, so to speak, that's restricted to one person family member, which could be carried on from deed to deed. That's the way. If it's good now for Jim, it should be good later for the next buyer. But we ask you to recognize that in reality, there is no difference in terms of the flow. The septic was designed for 5 to 6 people, and it was then calculated to be 50% above, as was done in those days, and as is confirmed by the records that I saw today from Jim from 1987 on the septic plan. So I thank you.
Tony, I have a question. For the first time, I heard mention of the fact that there's a kitchen. Can you and Jeff, you've seen this property, haven't you?
Yeah, yeah,
So there is a bathroom and a kitchen.
that's correct.
Okay,
A kitchenette.
a kitchenette. All right. It's a
Okay.
full kitchen. Okay. So this is not a bedroom. This has a bathroom and a kitchen in it.
It is an apartment.
All right. Thank you. Questions?
We have no questions.
If I may respond to that just a little bit further, I did point out a moment ago whether his father uses the sink in the basement or in the sink on the first floor, it's still the same amount of water that he's using. This is not an apartment where we're bringing in a couple with a baby or strangers or collecting rent or anything like that. Thank you.
John, I have a question for you. Are we able to issue a variance, D2 or any kind, and violate DEP regulations? Right here.
Speak again. It came out
Closer.
soft.
Can
His
we,
question was, can the board grant a D3 variance if the DEP regulations on their face are not complied with? And my answer is that you're not supposed to judge. I mean, what's good for the goose is good for the gander. If I told him, the applicant, that you're not supposed to judge, how many gallons Jim Hill calculated, because first of all, Jim Hill's not here to testify or be cross-examined, so you can't consider any of that. But the purpose of the DEP regulations was to explain Tony's and my opinion that the ordinance is not met because what he applied for to the Hunterdon County Health Department was 4 bedrooms, not 3 bedrooms and an apartment. So my advice is, his argument is that regardless of what the regulations say, he has a history that the septic system is not overburdened. And his argument for the D3 variance is they will offer up, especially the restricted to a single person condition, and they'll make him deed restrictions. And he's waiving his right to challenge them. So you could get better restrictions on this thing than you could if he didn't offer it up, because I would be advising you, you can't do that.
Yeah, but wait, I think what Jim is saying, or my question is, his application is for a 4-bedroom, which brings it up to 650. If it is for an accessory and he should have gone for 850, are we approving something that the Hunterdon County Department of Health would reject because he doesn't meet the 850?
Well, you could do this. You could grant the D3. I'm not suggesting you do or you don't, but if now I understand the concern, you could say, yeah, we'll grant the D3 variance subject to you go to the Hunterdon County Health Department and you apply for 3 bedrooms and an apartment.
Okay,
Tell them that thing's an apartment. You could do that.
Can I ask a question?
No, you can't
No.
yet. That would get you the advantage of the additional restriction. And that would satisfy, because your concern is really, is the negative criterion satisfied? And are we allowing some violation of law?
right.
And if you put a condition that they had to go to the Hunterdon County Health Department, refile the application, and it's subject to their approval, then you're not violating the law. You're kicking it to the agency that has jurisdiction to determine that in the first place. So that's
Okay.
my answer.
Hey, John, but isn't that what you were recommending to begin with? That
Yes.
just Go to
Well,
them?
But
I
if he
was-
wants,
yeah,
if he
but-
wants a decision tonight,
Right.
I
I was
don't-
recommending that they go there in the beginning. They
Yeah.
wouldn't need your approval.
right,
He wants the approval tonight. To get an approval tonight from you, they need this D3 variance, because in Tony's and my opinion, they don't comply with number 5. His argument for you to grant the variance to let him deviate from number 5 is, we're going to give you a better restriction on the occupant.
That's
And then what Jim and Cynthia are saying is, but they don't want the board in any way to approve something which would be a violation. So
Right.
you would, under this theory, you'd grant the D3 variance subject to those restrictions and because of those restrictions, but you're going to make it subject to him going to the county Department of Health.
Right.
Then he gets his approval tonight and he still has to go there and then you're covered.
I mean, why give things away if the board won't take my heavy-duty restrictions? I mean,
They're
how
going to
do-
take your heavy duty restrictions.
I may be confused, but how the hell do you get a relative into your house? Is it become this complicated?
You ready for this?
To
In
do
all the
this?
other applications, it hasn't been this complicated. Quite frankly, this has been the most complicated application for an accessory
Tell me
apartment
about it. I
that I've
just
been
followed
involved in.
everybody's
I've
advice.
represented the board for 30 years,
Right.
okay?
I just followed everybody's advice from the township to the engineers to Dan over at the health board. And I've spent 10 grand and I've done everything everyone
Listen,
says.
you ready for this?
If I had
Do you
known
want to
this was
vote, do
gonna
you
be
want to
like,
vote
let me
tonight or
finish.
not?
If I knew this was gonna be like that, I would have never fought for this country, ever. I lost a piece of my body for this country. I would never have done that, never. But that's just me talking because I got a stepdad I want to see living out the rest of his life happy.
Okay,
want-
so I think we should make a decision. We as volunteers are spending a lot of time. We have a lot of applications. I think we're down to 16. So I would recommend that if that's what the applicant wants, that we move forward.
You want to vote, correct?
And if council is saying that it has to be conditioned upon,
I'm not saying it has to be. I'm saying if they have a concern with the approval violating law, the way to get around that concern is to impose that condition. I specifically said, I am not taking a position whether this application should be granted or denied. I'm telling them, Mr. Ferraro and Ms. Schaefer are concerned that if they grant it, basically, they're going to allow a violation of the DEP regs. So I said, if that's your concern, then grant it, but make it subject to going to the county board of health and filing an application, not for a 4-bedroom, for a 3-bedroom and an apartment. Then they've kicked that issue to the agency that has jurisdiction over that, and they will decide whether or not, and that's the correct agency to make that decision.
right, with one exception, that we go back to the county board of health, not just for an accessory apartment, but an accessory apartment with these restrictions already.
Yeah,
imposed.
correct.
Yes.
And given that, yes, that's what we would ask them to vote on tonight.
Yeah.
Thank you.
John, I have one more question. You said earlier that if they got approval from the Board of Health, we didn't have to do anything. So
Right.
why are they insisting we do something which they're gonna have to get the Board of Health approval anyway?
Because that's their right. Okay, that is their right. They filed the application. They have the right to ask for a vote on their application, and you have an obligation, once they say, we want to vote, you have an obligation to decide their application.
And technically, if we vote them down, they can go to the Board of Health and get the approval, and then they don't come back to us anymore.
Correct, but if you vote it down.
The
you don't get
restriction,
those- You don't
yeah.
get those restrictions they're
Right.
offering up. If you grant it, subject to the Board of Health.
Right.
You get the restrictions.
Okay.
Give and take.
Hey, John, I have one more question. Initially, you were talking about special reason for
Yeah,
D3
the
variance.
special reason here would be that you're going to get a restriction you otherwise wouldn't get.
I just want
In
to
my
clarify
opinion,
that.
that's a special reason.
Gotcha.
Any more questions?
If I may, the other special reason is the lay of the land itself. It's impossible to extend the field.
Well, that's, okay, that you have, with all due respect, they cannot consider that. You need an engineer. You're not qualified to say that. What's that based on? Your conversation with Jim Hill? Where's Jim Hill to cross-examine him?
Yeah,
It's also,
He's not in the room,
well,
so
I
don't
am
go
also
there.
an engineer and it's based on my review, but I'm not testifying. tonight.
Correct.
I'm just-
And if you wanted to testify, I would say you're not competent to testify about that because you're not an engineer. You will be based on hearsay.
I
On what
am
Jim
an
Hill told
engineer,
you.
but I'm not going to testify. Thank you.
Brad or Steve, do you have any questions?
Okay, if you're an engineer, you want to testify as an engineer about it?
No, that's a conflict because I'm here as an attorney.
Okay.
Brad or Steve, any questions?
Stop for 1 second. Your PE is still in full force? Yeah, okay. Well, you can't testify or you'd be engaged in the unlawful practice of engineering. Forget the conflict. Yeah, that'd also be a
Okay.
problem for you.
No question here.
Steve?
No questions.
Any more questions? Otherwise, we'll close for deliberation. Yeah.
Public.
Sorry. Is there anyone from the public that has a question?
Questions or, can I suggest questions or comments at this point? This is the end of the application.
Yep.
Now, just remind me, did we take comments last time? Did I swear you last time? It was- Yeah.
Jonathan Simonoski.
Whoa. Nice and loud. Spell your last-
Jonathan Simonoski. Yeah, I just wanted
Could you spell
Whoa,
that
whoa,
for
whoa,
us?
whoa.
Could you spell that for us?
Symonoski,
And your address.
23 Forest.
Okay, and you were sworn last time and you remain under oath, correct?
Correct.
Okay, so these can be questions to the applicant, not to the board, or
Right.
comments to the board,
Uh,
or both.
How about any township engineers?
Yeah,
Okay, my only question was, Jim recently had a survey done, and I noticed that his driveway is on my property. And he also has the neighbor's fence, or he has his fence on the neighbor's property.
Right.
And I want to see if that's going to be
Right.
addressed.
those are private, in my opinion, those are private property issues, right? That's not for the board. The board, like I said before, the board is not going to go through calculations
Right.
of the septic thing. That's for the Board of Health. I mean, the Hunter County Department of Health. The private property things, that's between private property owners and the courts. That's not for the board.
Did it have to do with zoning at all?
Nope.
Okay, all right, that's my only question.
Yep.
All right. That's it.
Comments? You have any comments?
No, we're good.
Okay.
Okay, let's close for
Well,
deliberation.
Ask any other questions or comments from anybody?
I don't think there are.
Nope. Okay.
Who'd like to start? I'll start. After hearing all of this, Mr. Radigan assures us that his leach field and his septic system are satisfactory and would be approved. That's yet to be determined. I'm willing to accept the restrictions that the attorney has put forward that would be put on this apartment, but I would insist that they go back and get approval from the Department of Health for the septic system, which is exactly what John Drill had said. I think we're not in the business of deciding for the Department of Health what's right and what's wrong. So it's my feeling that we should ask that Mr. Radigan go back to the Department of Health to make sure that the septic
So
system
you
is
would
adequate.
grant the D3, subject to the restrictions that we've discussed, plus the additional condition that they have to apply for and obtain Hunter County Health Department approval for 3 bedrooms plus the apartment.
Correct. After all, it is an apartment. It has a bathroom and it has a kitchen.
Who's going next?
I guess I have a question. I want, with all those restrictions, if they go to Department Health and they are denied,
Yeah, then the approval is
Is-
null and void,
thank you.
and I'll have something in there that says that.
Okay. Go on, Kevin.
I'd be in favor of this application based on the return to the Board of Health.
Oh,
for-
by the way, this is a deliberation right now only on the accessory apartment. You also have to deliberate, once you finish this, you have to deliberate on that, on the deck. And Tony will remind you guys, it started as it morphed. We'll remind you of what you have to deliberate on that.
Yeah, I was already thinking about the accessory apartment.
Right.
Sure, We'll do the deck later, but I'm in agreement that, I mean, the testimony needs to be supported by the,
Kevin, can't hear you.
the testimony needs to be supported by the Board of Health's approval regarding the septic as well.
I would be in favor of it with the restrictions we've identified.
Including the Board of Health?
Absolutely.
Okay. Jim, Randy?
I agree with my colleagues, as long as there's restrictions and they have to go to the county board.
Okay.
I would go with the application.
Jim, we didn't hear what you said.
I really didn't have any comments, John, but I'll say this. Somehow or another, Is it working?
Yeah, it's working.
Okay. Somehow or another, the applicant has to be made to understand that if and when his stepfather, whoever the occupant of this apartment will be, passes away, the approval, if granted, goes away with them.
No.
Okay. If you want that as a condition, then you have to say that. They have not offered that up.
Nope.
Well, I think that's, you know what?
No way.
Okay, so
I would like to see that in our
if
resolution.
it's not in the resolution, I assume you're voting no on the application.
Yes.
Okay. Who else?
Okay.
Maybe
Anyone else want-
it's Brad Perry, maybe I could just add, I understand it's the applicant's right to request the restrictions, but I also envision that if you were to go to the Board of Health or you get the
County Department of Health.
Department of Health, get their clearance on the septic issue, I would also be in favor of not having these restrictions. I realize they're being requested, but they don't seem required if the Board of Health grants it sounds like they need to be requested to grant anyway.
Right, but Brad, they want to vote tonight. They have not agreed just to go to the Board of Health.
I
the county-
understand, yep. Yep, I'm just putting
So
that up.
to get a
I
vote
understand.
tonight, they need to show special reasons. What's the special reason if the board is not getting additional restrictions? What's the special reason to justify the D3 variance?
Yeah, I understand the situation. I'm just putting that thought on the record.
Steve?
No
Steve?
comments. No comments.
Okay.
I agree with what you said, Chairman.
Would someone like to make a motion?
Oh, sorry. Well,
John, don't we want to do the D3 variance first?
hold on.
Yeah.
Okay, hold on. Jeff raises the issue, because it's a conditional use, the ordinance requires conditional use approval. So what you're saying is if they went to the county health department and got the approval to satisfy, you're saying that would then have to go to the planning board for conditional use approval. If they grant the D3 variance, they can also grant conditional use approval. So if this board, if this board is going to grant the conditional use variance to allow the deviation from item 5, put him out of his misery. Based on the fact that you'll be granting the D3 variance from deviation 5, also grant conditional use approval tonight, which basically says you comply with everything other than the one that you deviated from, but we granted you relief from that. Okay? Thank you.
All right, do we vote on this or do we talk about the deck?
So we got to talk about the deck. So the deck, I think, is item 7 of Tony's and Jeff's March 31 memo. And this was totally hashed out. I just want to remind everybody. I'm going to read the comment first. The comment is the South Branch Raritan River tributary is along the eastern portion of the lot. Based on the survey prepared by Glenn Kentrorsky, the house and attached deck appear to be within the preservation of natural features encroachment and structure buffer. That's ordinance section 296-141, which you guys are very familiar with, again, from your favorite case, the Wawa case. After township inspection, the side deck was installed without permits and is within the stream buffer area. The applicant shall apply for a variance from section 296-141 or remove the side deck. And then there's a photo in their report. Now, I believe, I'm not testifying, my recollection, you know what? Instead of relying on recollection, what did Jeff, what did you ascertain last time about that deck?
The existing deck was approved by a zoning permit.
So the existing deck was issued a zoning permit in error.
Zoning and building?
Yeah.
Zoning permit and construction permit. So the applicant, in my opinion, justifiably relied on that. So what I said was, there's two ways of handling this. One way is to just ignore it, because no one can ask him to remove it. If you grant a variance for it, you need a reason. What's the reason other than you don't want to put him through the financial cost of removing it? Because I've told you how many times that finances are not a hardship. They can't be considered. So my advice on the deck, quite frankly, is to ignore it, because you better hold on to that zoning permit and that construction permit, because that will prove, stop.
Just for clarification, the deck, the main deck got approval, the side deck never got approval.
That, I said the side deck got approval.
No, the main deck.
Okay. So you're telling me they got an approval for the main deck and he put a side deck in without asking?
Yeah.
That was not my recollection of this. I confused it. So you need, what's your argument to allow an illegal deck to remain in in violation?
That area that's now deck was like a patio when we got there. Bad for him. All right, you asked me, I'm just.
Yeah, tell us.
And so what I did is I made it palatable for him to be able to sit on the deck. I can tell you another thing. In the back is the stream, which is, first of all, the three houses next to me, they all get closer to the stream than I do. Second thing is, I left from the stream a 50 by 200-foot strip.
Hey, can I ask you something? Why didn't you apply for a permit to run this by anyone
I
at
don't
town hall?
I don't know. It seemed like a deck. It wasn't even 3 foot off the ground. It was wood. I had the opportunity when they were here. I mean, it's a little deck. It's not even 3 foot off the ground.
I thought that this was a non-issue because I thought that they had zoning permit and construction permit for,
Can I ask a question?
yeah.
Jeff, do you mind coming up here for a minute? Okay, I'm looking at what was sent in with the application, okay? No, time out. So this is what he put in with the application. There's no deck. You went out, that's the deck you're talking about, and it's not on the drawing here. Okay, I just want to make sure it's not on the drawing that when they applied, when you went out, you took a picture. Okay, thank you.
For the board members, the deck that we're talking about is the deck that is right in the center of the architectural rendering. And it's the one that's 62.8, what is that, 84 feet off of the stream bed. And it's the smallest of the two decks.
But Mr. Glynn, what is your argument for a C2 variance to allow the illegal deck to remain in its location, which deviates from the ordinance?
To be honest, I didn't address that today, but I do know that there was a.
Can't hear you.
To be honest, I didn't address that today. I wasn't aware that it
Well,
was.
I was, quite frankly, I didn't know until just now, but
I understood from some document or discussion, the same understanding that you had. But I will say that there was a concrete deck already in place. And he brought it up off the ground so that his stepdad could manage.
so that satisfies maybe the negative criterion, but what's the positive reason? What's the,
So he can sit outside and look at all the preserve I did in the back.
it's not, it can't be a personal benefit to anyone on the property. It's got to be either a zoning benefit. Listen, that's what the law is. It's got to be
I know,
a
I'm
public
just saying.
benefit, or it's got to be a
I'm just
hardship,
saying
and it
you've
can't be
gotten so
financial
technical,
hardship.
You can't see the personal side anymore.
Not allowed to.
I understand.
Because you know what happens if they do that? Then it gets into, if they like you, they grant the approval. If they don't like you, they don't.
How about liking my 88-year-old stepdad who needs a walker and he goes out on his deck and sits there? I mean,
Inappropriate.
There was a concrete pad that was chipped and broken. He would have broken his neck sooner or later. All I did was change that
Yeah,
concrete.
all you did without checking. This is the biggest lesson I hope you learned through this whole process.
Sure did.
Okay, check first, ask first.
Sure
Don't
did.
do and ask for forgiveness.
Absolutely.
What are you guys gonna
I have a question about the side deck. Does it have access from the basement or is it
Just from the basement.
the side deck? And how about the main deck?
The main deck is from the house.
And the
The first
issue
floor.
is environmental issue, right?
Yes. How does he get up? How does he get up on this side deck if it's elevated off the ground?
Yeah, when you come out of his apartment, you hit the deck and there's a walkway. And the walkway goes up these wooden, in fact, Miss Fania knows about it. Well, never mind.
Yeah, don't bring her into this,
Right,
please.
all right. So there's like a long 3 or 4 steps, then another long 3 or 4. It's such a gradual uphill that he can handle it with his walker. It's not steps going up to the first floor. It's like elevations that are, if I'm explaining
Listen,
myself.
Board, I don't know what to tell you on this because you can't grant a variance for no reason. And they haven't given you a reason unless some board member can think of some reason. And I'm not suggesting you do because the burden's on the applicant. I mean, it doesn't happen very often, but in my 30 years here, the board has denied things like this and the applicants had to rip things out that they put in illegally.
How many square feet is this deck?
9 by 13.
9 by 13.
30 inches at its highest point, flat from the door going out the back, out about 9 foot. So it's not off the ground, it's flat out going out 9 foot. No, it's not big enough.
I literally don't know what to tell you. If you wanted to grant this variance, someone's gonna have to give me a reason to put in the resolution. Why don't you deliberate on the side deck?
Tony, what is the, to be legal, what would the correct setback be? 75 feet? 100 feet.
To be, it's illegal in this location. You have to put it somewhere else.
Would that mean all the 3 houses beyond me that all have decks, they're illegal too?
Listen, this is about your property. This is not about, who knows, maybe they got variances for them. When were the decks put on? I mean, that's like if you're speeding on the highway,
Hey, I'm
right?
not gonna
And
be like my
someone
neighbor.
passes
We
you and then the cop pulls you over and you say,
Right.
hey, he was going faster than me. If you're
Gotcha.
still exceeding the speed limit,
You decide.
the officer, not the cop.
All right, so I need to ask another question. It's 100 feet? Is that true?
100 feet for the structure, 75 feet for
So are we saying that technically his house is in violation?
Yeah,
Back in 19,
House is grandfathered.
87,
The house is
okay,
grandfathered.
okay,
it used to be 75 and 50.
okay.
Right.
Township changed it to 75 to 100.
Right. This is not a question, in my opinion, of the negative criterion,
Mhm.
because this is a question of the positive criterion. You need some reason, either hardship, if it's a C1, or a public benefit, if it's a C2, not a private benefit.
Suppose there was a patio there 30 years ago when they first put the
Right.
house on.
Why can't you have a patio for your father-in-law? Why do you need a deck for him? Why can't it be a
No,
father-in-law?
The only difference is the material.
Okay.
This is wood.
Right, explain. What was wrong with the patio for him that you had to
It
put a
was
deck in?
chipped up, it was shot. I would have had to redo that. It was less expensive, but expensive to put the deck up.
I understand, it was less expensive, okay? That's not a reason for them. You had a patio
Okay.
that the
I
guy could
changed the
use.
material.
Is it the same footprint as existed?
Sure. Probably 30 years. But of course now, everything is complicated.
Yeah, it sure is.
No offense to anyone. I
Let-
understand your difficulty on the board.
Let's start with, what's the definition of a deck? What constitutes a deck? If you have a concrete patio and you cover it with wood, Does that make it a deck? What is a deck? Maybe the answer here is that this is not a deck.
Even if patio, if he put if he ripped out the patio and put a new patio in, he'd still need a
No, he
variance.
covered the patio with a wood floor.
Yeah,
The patio pre-existed, it was in violation.
it wasn't
to
in
begin-
violation. The patio was grandfathered. Once you either remove something, it loses its grandfathered status, or once you add something to it, you don't have the right to add to a grandfathered. You need a variance. There's
Where do you
cases that
draw
say
the
that.
line? You
Huh?
can't put wood on top of
Correct,
concrete
but then
that's
not
already
without a
there?
variance, correct. That's where you draw the line.
Okay, I have a question for the
He could repair
applicant.
it, but
So-
he can't put a new one in without a variance.
Are you saying the deck, that there's a doorway from the basement to the deck?
Yes, ma'am.
Okay, and that's what's in this picture. That's a doorway.
That's his door.
So the gentleman, the elderly gentleman, is able to walk out from his apartment
Yes,
straight out onto the deck.
yes.
I
Not
thought you
ha-
said he has to go up a slight incline.
Yeah.
Then I explained myself.
the outside, from an
automobile
driveway.
If you look-
These steps are very deep. You can walk through the water. You can't go up that stuff.
Are you saying the way he gets into the apartment is over this deck?
It's over the deck and onto the walkway, up the stairs in front of the house and around. He uses a walker.
To answer this question, can your stepfather get into the apartment without stepping on this deck?
No.
No. So if
Why
you
didn't
see
say
the,
that? There's the reason.
yeah, so if you see the picture, it's a,
I didn't-
it's a
listen,
door.
I'm confused just being here.
Yeah, at this point, come on up. First, identify yourself for the record
this
and
is the
explain what you want to show.
Yeah, I want to show like
And
the,
then this is the walkway that he.
Your name.
The
First,
zoning
identify
State your name.
yourself
Oh.
for the record.
Jonathan Simonoski, 23 Forest Drive. The original survey that they submitted
Mhm.
has, it says concrete slab. See how tiny that is?
Yep.
If you look at the new survey, you can see the deck, which is probably about 10 times the size of the concrete slab. And you can see there's sidewalk going on the left and right. See that?
Yes.
So there's a big alteration. You see what I'm saying? That's not
Yeah.
just a little, that's not a little, thing. You're.
So what you're
adding-
saying is,
He's adding the sidewalk.
he said that it was the same size of the patio, but in
It's
fact,
not.
it's not. It's larger.
It's not truthful.
I really,
It's probably-
I paused there because what you're referencing is this picture,
Correct.
which is higher definition or further away, and then you're referring to this picture. So I understand what you're saying.
Mhm.
I
Look at
don't,
Tony has.
I don't know if that's true.
Let's ask Tony to scale it and see what the case is.
The thing is that patio was there for a long time.
The
I don't
question
know
is
how
this,
long,
are you
Because it was cracked and everything.
Miss, are you sticking with your testimony that the deck is the exact same size as the patio was? Yes or no?
I don't know, it could be a foot different, maybe. That's it.
John,
Can you take a 5-minute recess?
we're at 8:15. Normally, we should be moving on to the second
You know
application.
what? Maybe we should move on.
But then, but it was concrete slab, they didn't- right. So
What
now
happened
you
here
see
was,
this is the
Tony,
door
correct me if
right
I'm
here.
wrong, when they submitted the application, the survey that they submitted did not show the deck. Okay, these guys caught it. Then they told him, wait a minute, something's wrong here, resubmit. When he resubmitted, lo and behold, it shows the deck.
They asked me if,
I understand. He asked me a question, which was, when was the survey submitted?
no, what I'm saying is when they asked me about the deck, I told them the truth. That's why they caught it. It wasn't because I lied to them. I said this was a crumbling rock thing here, and I changed it to wood. Now, I don't know who did it. I don't know when.
Okay, can I ask you something? The original thing you submitted with the application, did it show a deck?
No,
The original survey that you submitted with the application, did that show a deck on it?
I don't think so.
Correct. They asked you to submit an accurate one to show the deck,
Yes,
correct?
yes,
Thank
I
you.
did that. I got a survey with that on there.
I understand.
May I make an observation?
Yeah.
Most likely that was from times past,
Yeah.
and my client didn't create that document, and there was no intention to hide anything. It's just that someone took a very old plat, if you will, or drawing and rendition and presented it.
Who was the somebody? It was 2010. It was him. He attached it to the application.
Right.
Not somebody, it's him.
2010, well, he didn't create that
I got an
document.
affidavit of no change on that survey. In other words,
But you changed it. You put a deck in, right? When did you put the deck in? What year?
4 years ago.
4 years ago.
On top of that.
Right.
Let me just
And
say,
then-
I did an affidavit of no change on the survey. I accepted their survey. That didn't mean it didn't have that concrete there. It means I did an affidavit of no change when I closed on the house to save money on the survey. Everybody knows what an affidavit of no change. Do what you want. What's that?
You have a survey that's dated, that survey is dated 2010. It was dated prior, it was dated before it got grandfathered in. Then you have, then maybe you have a case that this was an old survey, it was like the deck and it had been grandfathered into everything.
Whatever you say.
Whatever.
Okay.
Yeah. What he's saying is, we're all assuming that the deck is grandfathered. We don't even know that is what he's saying, because the survey showing the deck is from 2010. Can I make a suggestion? At day 15, you normally break, you have this other applicant here. You guys either have to continue him, or you got to vote on this last.
I think we have to go to the second application. That's always been our policy, that we spend the first hour with the first case. If we don't get finished, then you're going to have to wait until these people are finished. If not, it'll have to be continued.
So sit out in the audience. Hopefully they'll finish.
I know Ken has to go. Can we continue it another time or do you want to wait?
Are you crazy? You wanted to vote tonight. You want to continue it some other time?
Oh, yeah, let's.
Sit in
we'll
the
wait
audience and wait to see if they finish.
All right.
We'll remain, thank you.
Thanks.
Okay, we're going to take a 5-minute break.
So now we don't.
He's gonna stay. If these guys finish, they'll come back. Yeah. Yeah.
So they didn't have counties, they could do whatever they want.
Hey, Jeff.
So get up at 3 o'clock in the morning. So get up at 3 o'clock. No? I wake up 5:30. I have nowhere to go.
Start the,
We're
okay, thank you.
good.
All right, we'd like to get started again. I'd like to call the second application for this evening. BOA case number 10-2021. The applicant is Esco Precision, Inc. The block is 36.02, lot 14, 15, and 16. Jim, please. That's numbers 7, 11, and 17 Royal Road. The application is for a primary and final site plan with D1 use variance for proposed industrial/flex building.
Thank you. Good evening. Gregory Watts here on behalf of Esco Precision Products. We've been before you before.
You gotta get closer to that mic, Greg.
Until we wound up on the floor over there with the maps. So
Right.
we're back
So
and
just for the record, this hearing commenced on April 7, 2022. There was a little thing before that, but the hearing commenced on April 7, 2022. And the applicant's engineer was told to basically tighten up the plans and see what you can do about satisfying a lot of the comments in the professional reports. And not that I'm prejudging anything, but it looks like, at least from looking at the reports, that a lot of progress was made.
yes, I believe so. And the meeting was held with my clients, with Mr. Hajar and with your attorney, to make sure that all the i's were dotted and t's crossed, which gave rise to technical memo number 5 from Tony, which you have all had a chance to review. And basically, all of the items in there are now either conditions of approval or have been satisfied. But Mr. Kendall, our engineer, is here in case there's any lingering questions.
Right, so my only general question is, the board's practice, if you don't mention a comment in one of the reports, and the comment says, make this change, and the board decides to approve the application, I'm going to interpret that as that's going to be a condition. So the only comments you have to address in the reports are ones that you think need clarification, not to say, we agree. If you don't say anything, you agree. It's if you don't agree with something, or you want a clarification of something, or you want, the wording changed a little.
All right. I believe our engineer was satisfied with the ones that are still to be conditions of approval.
And now I just have to get an additional person sworn, and that would be our substitute planner, Aaron Carden. So Aaron, can you raise your right hand? And do you swear that any testimony you give in this matter will be the truth, the whole truth, nothing but the truth? Okay, and let me just see what else I have here. Okay, so we have Adam Candell was sworn last time and testified. We have the two applicants' representatives that were sworn, and they're still here. So if any of the three of you have to testify, everyone's been sworn, and now all the board experts sitting here have been sworn. So go ahead.
Very good. Well, if there's no issues with regard to technical comment number 5, we're prepared to move on to traffic and landscaping.
Yeah, your technical review report.
Your review number
June
5.
13th. What he's saying is they agree with everything in there as a condition. Now, if the board has any questions about any of them, fire away. But as far as the applicant's concerned, everything in Tony and Jeff's memo now is agreed to as a condition, if it hasn't been satisfied already.
Okay.
So whose memo are we doing?
Okay, Adam, which one do you want to do
Hey,
first?
John,
Yeah.
how about item 164 on Tony's?
Okay, Tony, can you give an explanation?
So this is a setback variance. It's basically an accessory structure, accessory use, the detention basin to satisfy the stormwater management. And in that zone, this
Doesn't differentiate
doesn't differentiate between
principal structures and accessory
principal structure
structures.
and accessory. So the setback required is 50 feet and they're proposing 27.
And you would recommend
I don't have any objection.
you don't have any objection because
And
it says
explain
variance
why.
is required.
Because 27 and a half feet is good
Got it.
amount, good distance.
So you're in agreement the way it is, and you would propose us to grant variance for that.
I don't have any objection.
Okay, perfect.
Yeah, I just want to give you some information that I just got today. Item number 7.
Oh,
Item number 7. So
when you say item number 7 on your June 13th memo,
that's correct.
that said applicant agreed, condition of approval.
Yeah, I have the lot number and the address.
Oh, okay. Why don't you give it to him? I thought you were throwing me a curve.
I was gonna have.
So it's
Yeah.
lot 1401. And the address is gonna be 11 Royal Road.
There is 3 existing lots that to be merged as part of this application.
That's
Right.
correct.
Listen, if that's all you have, no problem.
Yeah. You did make us nervous.
Made me nervous. Forget him. I was like, are you kidding me? Traffic?
We can do traffic first.
Okay, so this is the April 5 traffic review number 2 or the more recent one?
June
June 14th.
June 14th. Okay. Yeah. Jay Troutman's memo dated June 14, and they handed it out in the packets for everyone. Oh, and I have it. Okay, so a lot of these are just commentary.
Number 12.
Number 12. So number 12 says, the proposed do not enter sign at the rear of the building near the northernmost loading dock is facing the wrong direction. The sign should be relocated to the north side of the traffic aisle for better visibility. Partially addressed, sign is still in the wrong location and should be relocated to the north side of the traffic aisle near the proposed one-way sign for better visibility, but I thought I saw an email late in the day about this.
That's correct. We were going back and forth on emails with the traffic. Oh, no problem. Sorry, for the record, my name is Adam Candil, Kandil.
And can you describe the last email and the date or the time?
The last email from my recollection was June 15th. And it was,
Do you have the email with you?
I don't have it with me.
I don't know if this is the latest, but this is.
Do me a favor. You two can show him that. You show him what you have, you show him what you have. Let's get the last email, see. Tony, do you know what the issue is?
Yes, yes,
Okay, is it resolved?
yes.
Do me a favor, Tony. Forget the emails, just what was the issue and how's it been resolved and what do you need?
So
me to do?
Adam provided us with a revised plan showing the location of the sign, and Jay agreed that that's the right location. The other comment is we're looking for,
Stop for a second.
okay. So that satisfied 12.
12 is technically not satisfied because you need the plan revised,
Yeah,
right?
so it's, yes.
So can't I just leave 12 like it is? You guys know what the change is gonna be, but I don't have to change 12.
You can keep,
Because the plan that he reviewed, it's in the wrong location.
correct.
And you're gonna put it in the right location, and apparently you worked out with Tony and him where it's gonna go.
Correct.
We don't have to know that. It's been worked out, yes?
Yes.
Okay. So you don't have to discuss that one. What else you got?
And
13.
13, same.
Okay, so if I read 13, you're gonna tell me it's been worked out. If I read 13, just tell me if I would have to change the language of this. In order to be consistent with other truck routing restrictions in the area, this office recommends that the truck traffic be restricted from going north on Royal Road between the hours of 10 PM and 7 AM. During daytime hours, trucks should have the ability to travel north for access to the traffic signal at Route 202 and Case Boulevard instead of using Church Street. So read me the language that you worked out with him, because I will put this one in.
So that is specific in that email that Tony has, which we're agreeing, Tony and Jay agreed on the actual sign there. So it's a
Okay, so-
left turn.
Let me read this.
Yeah.
That's the sign?
Yes.
Okay, so the condition would say plans shall be revised to add a new sign that faces into the site where trucks exit, and the sign text shall read, colon, and then quote, in caps. You want them in caps?
Yes.
Trucks, no left turn, 10 PM to 7 AM. And you guys agree with that, right?
Yes,
Okay.
we do.
Question, in the I2 zone, what are the hours of operation? What are they limited to?
24/7.
24/7 in the I2. Okay, thank you.
That's the traffic memo. What do you have left?
Landscape and then address.
Can I ask a question before we jump? Tony, I'm sorry, naive. You can't make a left between 10 at night and 7 in the morning, but you can make a left all the other time?
Yeah, the reason is the multi-development complained about truck traffic at night.
Okay, okay,
That's the reason.
that's fine. Thank you. I thought there was some other reason. Thanks.
Okay, landscape memo. What's the date on that?
1626.
Okay,
Should I go by one, John?
well, again, if you agree, you don't have to mention it. It's if you need clarification, or if you don't agree, you have to mention it. So if you're gonna tell us that you agree with everything, that's all you have to say.
We do agree with everything.
This is how these big applications should go. You work out all the engineering stuff, so they're left with the big policy decision on the variance.
Yeah, I want to particularly thank both Tony and Jeff and the engineer for working all of this out. I'm well aware of all of the work that they did the last couple of weeks. Thank you all.
Yeah.
Wow.
Is there anything else? Planning. Now, let's look at planning and let's see. A lot of these are comments, but there's some questions in there and there's some variances that are pointed out. So I'm going to suggest that we let the planner go through the memo and bring up things that he wants to hear a testimony about or he wants to have answered. And then we'll just make sure that you had testimony to cover all the variance issues and the exceptions. How's that sound?
Certainly, we'll do that.
So Aaron, this is your June 15th memo. You need a mic, can you give him a microphone?
I'm not gonna see that.
Talk very loud if you need. Okay, we're good. We're good here. Okay. I think it's probably best to start with the architectural plans and sign details with this. We need
What page of your memo?
page 5E.
Okay.
Page 5, item E. There were questions with regards to the color of the concrete panels for the front elevation, rear elevation, side elevations, north and south. And that was that. So
Aaron,
Yes.
what about page 4, B, 1, little I, down at the very bottom? This does not comply the variance pursuant to NJSA
Let's start with the
4055B.
accessory structure variance.
Right.
Okay, so let's start with the accessory structure variance, which is,
So again, this is on page 4, item B, Roman 1.
yes,
And why don't you just read it first?
okay. According to section 296, 131A3, no building shall be erected, no existing buildings shall be altered, enlarged, or rebuilt, nor shall any open space surrounding any building be encroached upon or reduced in any manner except in conformity with the yard,
Hold this, you were doing good. Slow it
Okay.
down.
except in conformity with the yard, lot area, and building location regulations hereinafter.
Jeff, can you get that mic working again? There you go. No? Just give it to Jeff. Very sensitive mic. He, yeah.
Even better. This is even better. Designated for the zone in which such building or open space is located. The applicant is proposing an accessory stormwater. Okay, sorry. Where should I start here? I'll start with the applicant is proposing an accessory stormwater and utilities outlet structure consisting of a water quality device, electric box, transformer, hot water box, and a meter pit / vault in the front yard wherein accessory structures are not permitted in front of the principal structures. And this does not comply with the ordinance, and a variance pursuant to C variance would be required here. So how,
So let's talk about that.
So I'll defer the planning testimony to Wayne, so he's the planner. So ultimately, at the end, if that's okay, if we can table
Yep.
that one for his
So
testimony.
Wayne, write it down.
okay, that's why,
Don't be like my brother up in here.
That's why I figured I would start with the items that would be addressed first before we get into the testimony. So that's why I skipped that. I would have come back
Okay.
to that with all the other
Yep.
variances.
Certainly
Because
appreciate it.
there's still the overall D1 use variance as well for what would be I'll go back into that, would be that the proposed, we'll go back into that as well, which also will be
Right.
part of the planning
That'll be
testimony.
all for Wayne.
That'll be all for Wayne when you provide testimony.
So go back to page 5E, architectural plans and sign details.
So essentially what we're looking for here is we just want to have some testimony with regards to the color of the panels on the front elevation, rear elevation, and side elevations on both sides. Just to get an idea as far as how this will look.
Yeah, I mean, we didn't decide on that right now, but it's gonna be neutral colors. I mean, you'll have maybe like black accents, but it's all gonna be neutral colors. As far as like exact colors, we don't know for certain. Oh, it's gonna be mostly neutral colors, so,
Let me just take some questions.
yeah.
Does anyone on the board, or does Tony or Jeff, who are township employees, care what the thing looks like? If you do, then speak up and let him say what he's gonna say. If you don't care what it looks like, then you can, I mean, valid questions, but if you don't care what it looks like, it's not gonna end up being a condition.
Well, timeout.
Yeah,
Turquoise is not my color.
okay?
Okay, so I
Neutral
would,
color.
neutral colors is okay, or acceptable to our township engineer and
Yeah,
assistant
no
township.
neon colors,
Can't hear you.
no neon colors.
So in other words, the condition would be neutral colors acceptable to township engineer. That agreeable?
Yeah.
That
Okay, thank
agreeable to
you.
the board? Okay, what's,
Okay, let's see. Next. Okay,
Aaron, you on page 6?
I'm on page 6 right now. It seems that the items that were addressed have been complied with. At this point, the ground, the signage, the ground signs, which I'm looking through, the setbacks comply. As well.
Tony, the size of the sign is 104 square feet. Limitation is 100, correct? Am I mistaken?
The ground sign?
This is the primary tenant
Wall-mounted sign.
owner, wall-mounted sign. This is on page 6 under signage, small Roman numeral I, and it's the third paragraph down.
So for the wall sign is 5% of the facade for each tenant.
Okay?
So I didn't review it recently, so is it compliant?
All right.
That's compliant.
Okay, thank you.
okay, so let's, Aaron, okay, your next thing that doesn't comply is page 8H lighting.
Well, I'll read out that section. According to section 296,
Put it this way, go to the last sentence in bold.
okay, the applicant is proposing a range of foot candles from 0.0 to 4.5, which does not comply. A waiver has been requested by the applicant.
So now, give the ordinance requirement.
The ordinance requirement is that the foot candles,
Maximum illumination,
the maximum illumination shall not exceed 0.5 horizontal foot candles or 0.5 vertical foot candles,
and it tells you where it's measured from.
which is, oh wait, sorry. The artificial light, wait, okay. So the maximum illumination at 5 feet inside an adjoining residential parcel or public right of way beyond from an artificial light is 0.25 horizontal foot candles and 0.25 vertical foot candles. Said illumination likewise measured inside an adjoining commercial or, okay, said illumination likewise measured inside an or adjoining commercial or industrial parcel or on a public roadway or beyond shall not exceed 0.5 horizontal foot candle or 0.5 vertical foot candle. No sight line, no line of sight to a flaring light source is permitted from 5 feet or more inside a residential or public right-of-way property line by an observer viewing from a position that is level with or higher than the ground below
And here's the next
fixture.
sentence, nice and loud and slow.
Okay.
Because this is going to be the basis of the question I'm going to ask the engineer.
Okay, compliance is achieved with fixture shielding, directional control designed into the fixture, fixture location, fixture height, fixture aim, or a combination of these factors.
So the question is, can you make it comply? If you can't, explain why and why the board should grant an exception to allow the deviations. So
Yeah.
by doing those things that Aaron just read, can you make this thing comply?
Yeah, so we have taken all the measures to try to achieve it by shielding and the direction and the height, but unfortunately, we cannot make it comply with maintaining, life and life safety and, safety at night.
Okay, so explain why. That sounds like that's not a hardship. It sounds like, but this is this an exception? Is this a site plan requirement?
It's an
or
exception.
It's an exception. So the argument's going to be impracticality because you need it for safety. That's what you're saying?
Correct, and they're
So
modern.
explain why you need it for safety.
So the lights we're proposing are modern LED energy efficient lights, and we have them shielded as best we can. And especially with regards to the neighbors, we have them pointing in towards our structure and shielded on the back. So cut off shields on the back. But there are areas where the lights, because of the area adjacent to the neighbors, even with shielding, there is some spillage that would.
Where are the deviations? Can you come over?
There's no neighbors. Yeah.
Also, can I add, it's an industrial zone. There's no homes around it either,
Right.
so.
Right, but you do have a hotel.
No neighbors. No, it's like TD Banks on one side.
Yeah, but you have a hotel on the other side of life storage, right?
It's like far back though, if you ever saw it.
Oh, I know exactly where it is.
So as far as the hotel is concerned, is there any issue there?
We're trying to find out where the deviations are on the site first.
Yeah, on the plan, and that's what I was looking previously to see.
So come on over. Jeff, can you get that hand mic working? Give it to Adam.
Like,
Do you know where the deviations are?
Some deviations, spillage on the street.
For the record.
So the only area where we have some spillage is where it comes on the street, but not on any of the neighbors.
is that Royal Road?
Yes, it is.
Okay, that's the street he's talking. Yeah, okay, just want to make sure.
Not the other road, right? Whatever.
No.
On the northern drive.
Okay.
Which backs up to
That's the only place.
two
Okay, so the only place where there's a deviation is where?
Yeah.
The northern driveway.
Okay, so it's not even a deviation to a commercial neighbor, let alone no residential neighbor. Is that correct?
That is correct, and we also prefer higher illumination on the driveway for safety purposes.
Yeah.
Okay.
is pickleball on the east side or is it the two manufacturing facilities that? It's the east. Okay.
Just for completeness, how much curiosity wise is the spillage?
We can't,
For completeness, how much is the spill?
Supposed
Like
to be
how much?
0.5, and what they're proposing is 0.6.
Okay.
okay, but it says the applicant is proposing a range of foot candles from 0.0 to 4.5.
Right.
That's not on a
No,
deviation.
across
That's
the site, not
that's
on.
the whole site.
So someone's gonna tell me the deviation is, give me the number of the deviation, and give me the requirement.
The requirement is 0.5, and what's proposed is 0.6. Right?
The 0.5 is the max, and 0.6 is proposed, and this deviation is at the driveway intersection where you'd want
The
higher illumination.
Right.
Okay. Aaron, keep on going in your report. Go to page 9. Now, the solid waste comply or not, you're describing what it is. Does it comply? It looks like it.
It does look like, it does look like it complies. And we're just describing how they're managing its boundaries.
Let's keep on going. That's it. That's the planner's report unless you have something else, because they're not, it doesn't seem to me that they're proposing any conditions.
I'm just asking for only asking for testimony with regards to the variances.
Right, and that's going to be given by Wayne Ingram.
So I got you there.
All right, we're prepared to call Wayne Ingram, our planner, to testify.
Why don't we just see if there's any members of the public or any board members who have any.
John Morgan Thomas, you have a report?
Well,
They said they
agreed
agreed with
Okay.
They agreed
everything
to,
in the report.
they agreed to the,
Very good. Thank you.
Yep. Okay.
Are there any questions from anyone in the public?
The only people online are our two representatives, right?
There's a new one that just popped up.
There is a,
He's joining right now. Jonathan. I don't know if he has any questions.
Jonathan, on the, who's zooming in, do you have any questions?
I just unmuted him, so.
Okay, so
Okay.
Mr. Watts, correct me if I'm wrong. We've now been through all the reports and all that's left is the planning testimony. Is that correct?
Do you have anything further? Do you have anything?
Small item is the hydrants, but that has been addressed.
The what?
Fire hydrant.
Okay. Okay, whose report?
This is,
This is March 31? And when you say it's been addressed, have you made plan revisions or?
we made planner revisions in our last submission, revision.
Okay, so the fire marshal hasn't reviewed it yet.
Yeah.
Right, so if the board approves this and I make these a condition, you're going to be able to comply with it.
100%.
Okay.
All right, I'd like to call Wayne Ingram. I'd like to swear Wayne.
He's been sworn. You just have to qualify him.
Has he been qualified too? I don't
No,
know.
you have to qualify him. I'm not saying he's not qualified, but you have to qualify him.
Mr. Ingram, by whom are you presently employed?
Engineering and land planning.
Yeah. In what capacity?
I'm the vice president.
And are you a licensed professional engineer in the state of New Jersey?
Engineer and planner, yes.
And you're a licensed planner?
Yes.
Land planner? All right, have you testified before the Raritan Township Board of Adjustment before?
Many times.
In both capacities, correct?
Yes.
And they've accepted you as an expert in both fields of expertise, correct?
So far, my luck's holding up.
And your licenses are still in full force and effect.
Yes, they are.
You remember to renew it recently.
Mr. Ingram,
But, okay, fantastic.
we accept Mr. Ingram. He's well known to the board.
Thank you.
We'd like to start with the D variances that have been picked out by the planners. That is for the flex use, which is not a permitted use yet in that zone. And there will also be multiple uses which also call for a variance. And I'll let Wayne address those issues.
All right, so forgive me if I sound redundant from the last application. We had a Pioneer Developers last year for a very similar case, but this is a very similar situation. The I-2 district is a large district in the township comprised of many lots and developments. Our subject property is 6.5 acre and currently contains 3 lots, as you've heard. Sure. The surrounding properties on Royal Road generally are 2 to 3 acres in size. Some of the surrounding uses include Life Storage, Cooper Electric, and TD Bank. To the northwest, we have other industrial uses on much larger lots, which access off of Church Street. The zone also uses in the zone are also tend to be broad and have those kind of uses you would normally see in an industrial park and zones, warehousing, manufacturing, trucking, indoor recreation, etc. What the applicant's proposing is an indoor park flex space. And quite simply, what that means is they want to use the property for multiple uses, what would otherwise be permitted in the zone. So taking other uses that are already allowed and combining them into a space. And that's essentially what both of the D variances are related to.
And I believe during the April 7 hearing session, Adam went through and listed those uses in the I-1 that they'd want to have here. And those uses in the I-2 that they would want to have here, and then those uses in the I-1 that they would agree they wouldn't have here. You guys recall that?
Yes.
Ah, okay. And so without having to repeat that, that's a suggested condition by the applicant, correct?
Correct. The same list that we discussed last time would be the same uses we're requesting. Yes. The same uses that we discussed at the last hearing are the same ones we're requesting tonight. So there's no changes or additions or subtractions from that list. So similarly discussed in a recent board application for the Northland Royal Road, the term industrial park exists in the township's parking standards, but it doesn't actually exist as an approved use anywhere in the township. So what this says to me is that there was a clear intention to allow a use like this because you created a parking demand for it. But again, in the broad sense, we're talking about allowing uses that are already permitted in the zone, just putting them under one roof. Industrial park flex space is consistent with this zone, as well as many other surrounding properties. I'd note that many properties on Minneconning Drive were previously approved in a similar capacity, having multiple tenants on the same property, as well as the recent Pioneer
Right,
application.
but those things were before the board came out with its interpretation.
100%. What I'm simply saying is this use would be consistent with many of the other properties in the zone and wouldn't be out of character with that
Okay.
zone.
So it's not a positive criterion reason, it's satisfying the negative
Positive and
criterion.
negative, yes.
Okay.
In that particular street, you see contractor trade uses, manufacturing, storage, recreational facilities, all existing on the same lots together. On River Road, there's other developments which operate with multiple tenancies on a single lot, and those uses are not necessarily consistent as one specific use either. Our intention here is no different. I would say as opposed to a single larger warehouse, which would be permitted, that could potentially generate larger number of trips for trucks with the same footprint. And the tendencies here are more akin to smaller local trade businesses than the larger single tenant operation. I think this property is particularly suited based upon its location within the zone, again being somewhat centered in the zone, not on a perimeter adjacent to other zones and types of properties. The surrounding uses are consistent, and we're consistent with those uses. Currently, as I said, we have 3 lots, so each could individually be developed. So in the same footprint that you see, you could have 3 individual buildings, 3 individual uses. But that would also come with 3 sets of utilities, 3 sets of driveways, all of those other things which are somewhat the same in terms of scope of what we're proposing, but have more impact. We're simply, by combining these into a single building, creating additional efficiencies to our design, which includes, again, less access points to the roadways, utility connections. We're able to create a more efficient impervious surface, and we can combine our stormwater management into one centralized location, combined on the site. This is a lower intensity use. What we're proposing is 25% of the allowable FAR. And at 41.5 feet in height compared to a 60-foot permitted, we're not getting anywhere close to what a total mass could be if otherwise developed, for a single tenant who would potentially go taller, add more office space, more FAR, things of that nature. So since the uses are all separately permitted, there's nothing about them that we think would be unsuitable to the lot.
And in fact, one of the uses that the applicant said that they would not have here, which is permitted, is a truck terminal.
Correct.
So I assume that what you're testifying to is if they had a large truck terminal, that would be more intense and a worse use than if they had multiple smaller of the permitted uses.
Correct, yes. So since the industrial park use is not identified anywhere as an approved use, but by itself, but yet multiple similar facilities exist, we therefore think it's appropriate and suitable to permit a similar facility in the same zone on a lot, which for all intents and purposes, as you've seen in the plans, can accommodate that use. As I said, the lot's internally located to the zone, and we have no surrounding uses, which I believe would see detrimental impacts from this proposal. There's multiple purposes of zoning that would be furthered through the application.
Whoa, slow, you gotta
Sure.
slow down now.
Purpose A, promoting the general welfare. I think we're providing an opportunity for smaller businesses in the township that certainly would fill a need. Many of the other facilities that are built previously are all well occupied, whereas some of the larger tenancies, a single use in the township, are not. So I think that what that shows is that these smaller uses will find a home in a facility like this. Purpose C, promoting light, air, and open space. As you heard, we're not getting anywhere near the permitted height or a full FAR, and I think that that's certainly serving that purpose of making sure we stayed well below what could otherwise be permitted. Purpose G, sufficient space for a variety of uses, including industrial. I think we've hit that multiple times, but we have a multiple tenancy use, which is not otherwise permitted for these types of facilities. But with that flex space term, it's a definite need that exists in the area. And finally, purpose H, design of efficient transportation routes to promote free flow and limit blight. Our location is convenient to highways. And I think, as I said, that combining these lots and reducing it to the number of access points we have is a more efficient access onto the roadway and will lessen traffic with these smaller tenancies. Regarding the negative criterion, I don't see any negative impacts to this application. The uses are exactly what you could otherwise see in the zone. And I think by eliminating the uses that we have and by seeing how other facilities in the township operate like this, that we can basically show that these will all operate harmoniously on the lot and will not be a detriment to those neighbors. We intend to comply with all the performance standards and nuisance standards in the township. I don't believe that there's any impairment of the town's master plan, zone plan, or zoning ordinance by virtue of the fact that only individual uses approved in the zone are requested.
Slow it.
And in my opinion, this use represents more of an unfortunate oversight in including it in a zone than an actual intent to never permit such facilities. In reviewing the master plan, I saw nothing contrary to what's accomplished by this development, in that it is consistent with the utility and circulation goals and did not appear contrary to any others. And I further see no impact to the adjacent properties, which are primarily industrial in nature. The project is no more developed than a conforming use, lower height, lesser FAR. Stepping over to the C variances.
Yeah, before you go to C.
Sure.
So there's obviously some reason, I mean, the Board of Adjustment explained its reasons in the Wawa case for saying that multiple principal uses are not allowed. Okay, so there's an explanation for why they're not allowed in the ordinance. But in your opinion, is there less of a problem with multiple uses in an industrial setting like this rather than retail, where if you have multiple retail uses, you could get a lot more traffic? But if you have multiple industrial uses, like you said, if they were on separate lots, you might even have more traffic. If you consolidate it, you might have less traffic. You have an opinion on that?
Correct. I think that goes to my point of, if they were individually developed as 3 lots, you would have more access points. In a retail setting, you have more of the public. Here, that's going to be a much lesser concern. So the uses can tend to be more, harmonious and less impactful to one another.
So you would, okay. Yeah, I'm good.
All right, so with regard to the steep slope variance, the planner's letter outlines the 20% or greater and the 12 to 19% slope
Slow it.
categories that are exceeded. That is specifically related to the rear of the property where we have what was basically at one point a constructed swale. So the swale has steep slopes leading into it, which we're proposing to remove. I would say this qualifies under a C2 condition. I think one of the main reasons you try to protect steep slopes is, because you're concerned about erosion and things of that nature. Our proposal will actually be eliminating all of the slopes. So, and I think it's important to note that the ordinance does not distinguish between natural and man-made. So, something that was man-made years ago is now considered a steep slope. And whereas we're removing that slope completely, providing an alternate drainage scheme that accomplishes our goals such that they're no longer required. And by eliminating the steep slope, we eliminate the concern of erosion. So the fact that we have a compliant stormwater plan, in my mind, effectively mitigates any negative impacts to this disturbance.
Question, does the stormwater plan consider what you just said?
I can't hear you.
Is your stormwater plan consider exactly what you said about removing the slope?
Yes, yes, they've designed it to pick up all of the water such that that
With your
swale is no
recommendation.
longer needed.
Got it.
Correct.
Aren't you putting back in there because the swale still exists?
There will be other steep slopes created by the application. And I suppose if they were to come back to you in a few years and ask to disturb them again, we'd be asking for the variance again. But again, it's the problem with that ordinance, not distinguishing man-made from natural
Yeah,
conditions.
but are you aware of any ordinance in Hunterdon County that distinguishes between man-made and natural? I'm not.
I do see that in other municipalities.
Which ones?
Off the top of my head, I can't name them. I don't know if they're in Hunterdon either.
None of mine.
Yeah. But I think it's an important distinction. Obviously, what you're trying to protect is natural steep slopes.
You're saying
erosion.
it goes, that goes to the negative criterion that they're man-made, they're not natural, and your positive C2 is that your stormwater.
Stormwater management is improved through the
is im-
application. We
right.
have reductions in runoff by allowing us to do this. And I'm going to lump all of the accessory structures and the setbacks into one because they all essentially are the same thing. Whether we're talking about an electrical transformer or a water quality structure or a water meter pit, these are all structures that I don't consider detrimental because they're routinely put in a front yard. One of the main reasons is access. Your utility mains are in the street. That's what you're connecting to. So you're not going to locate these things distant or interior to the site for when they need to get service.
Just very slowly list those structures that are going to have the setback deviations in the front yard.
We have the water quality treatment device coming out of the basin. Again, that's a basin to a treatment device to a discharge point. It kind of has to be in that location. An electrical box and a transformer. Again, those are the type of utilities you routinely see in a front yard because that's where the utility companies want to maintain them. A water hot box and the meter pit vault as well. Again, for the same reasons. It's accessibility, from a public road. You don't want it internal to the site. These are also not structures that are going to be highly visible or detracting or creating any negative impacts. They're, at most site plans, I would say they're routinely put in these locations. And I guess the last one, which I think we touched on already, was the variance for the basin being 27 feet where 50 feet is required. You already heard from the board's engineer that there is no objection to that. Just from again, a practical standpoint, we did significant soil testing on the property. We found two locations that infiltrate, a small one and a large one where you see the basin. So, we're practically constrained because that's the area that we can get the best stormwater management to meet the current standards in that portion of the lot. And there's only so much space we could put it in to accomplish it. So
And is that because you need it for infiltration?
correct. Yeah. To meet the recharge and other standards, we need to have an area where we can infiltrate. And to meet the recharge standards, we need to infiltrate. And we tested all over the site, and the location of the basin is really the only primary location that will accomplish that goal. But any negative impacts, I think, are mitigated with our landscaping. And again, it's a basin, it's a formed feature, it's, essentially below what'll be the grade, and we're screening it anyway, so it won't be a detrimental impact.
Those are the same reasons for having it here as well.
Correct. Yep. Yeah, we have to discharge it. It's really the only place it could be from a practical standpoint. And I think that touches on the variances.
Which was the one that was in Aaron's report? That was the stormwater basin.
That's what he just addressed.
Okay.
That's what he just addressed.
Okay. Okay.
Any questions from the board?
Yeah, I have a question. The planner.
Jim, microphone.
Got it. I have a question for you. How many different businesses can this flex space supply space for?
Okay, so why don't you
We show,
CO, tell them, bring up CO3.
page CO3 of the site plans delineates 7 potential tenancies. Now, it's not to say that, somebody couldn't take 2 of the spaces, 3 of the spaces, but that's a maximum breakdown of what they're proposing.
7?
And I believe that you named, or spacing on your name. Ryan. I think Ryan named Cerebus to occupy the space all the way to the left, which is south. And then tenants for 1, 2, 3, 4 for the other 6 spaces. Is that correct?
I'm just curious also for the planner. What type of crystal ball are you guys looking into? When we look around town, we have a number of flex space already approved.
Applications.
And we have another one on the board coming up before the board. How are you projecting the occupancies? It just seems odd to me.
Well, I think there's a need. If you look at the built facilities, again, on mini econing, you see, well occupied structures. A lot of towns are becoming more restrictive into where they want these types of uses. So, especially contractors, they're finding it very hard to find places to go. So your small plumber, your electrician, he's looking for a space that he can have, a small shop, run a few trucks out of, and the trades are busy, especially right now. Construction is booming, and these guys need places for their operations.
I think you're all being very optimistic about the future growth of the area, personally.
Just by way of background, Jim was on the board way back when all those golf facilities came in and got approved, and they all got constructed, and then are there any golf facilities that are still in operation in the town? One. So he's asked.
Well, again, I think what you're hearing here, which is a little different than like even the Pioneer application, the last one that was approved. They're going to be occupying what would be the largest single tenancy of the building. And, I think their goal would be over time, they would hope that their business would improve and, could even maybe grow within their own building. So, we know we have at least, one solid tenancy there. So that, that's going to be supportive of the building. Who knows, maybe some of this may come down to who's the first person to put a shovel in the ground, and, first building up is going to get the tenancies. Even in that other application, they had 3 buildings. The intention there would be, they're not going to construct all 3 buildings at once. They're going to wait to see how things progress. Maybe they only build 1 and find it built out.
I find it interesting.
Yeah.
It's an interesting thing to observe happening.
Right now, it is, it's one of the most popular projects, the types that we're working on, Yeah.
Question based on that. Has the ordinances changed? Because I know, like Wayne had mentioned, plumbers, snow removal, where property owners can only have 1 commercial truck. Was that always in place? Is that possibly why some of these might go there? Because now people who are plumbers and have commercial vehicles in their house.
The ordinance changed to actually allow 2 trucks
2 trucks.
per lot.
It used to be 1, it
Used
changed to
be
allow
one,
2.
yeah.
Okay, all right.
And higher tonnage as well. It used to be 5 tons. Now I believe it's 7.
Okay,
14,000 pounds.
all right, thank you.
Other questions? Are there any questions from the public?
And the professionals have no questions.
Okay. Are there any comments from the public?
The applicant has nothing further.
Okay, I think we're probably set for deliberation. Would someone like to start?
I'll start this time. First of all, you guys have done a wonderful job. from where you-
Into that mic.
You have done a wonderful job considering where you were a month ago or 2 months ago. So thank you for that. I just second what Chairman said. Looking at everything, to me, there are more positives about this. I really, being a small business owner, I understand where you're going with this thing. And quite frankly, the municipality needs that. So very good idea. And you have balanced everything as far as reducing traffic. Environmentally, it's more sound than what it would be if there were 3 different tenants. So very nicely done, nice plan. So I would totally support it. Yeah.
I'll go. I'm also in favor of the application and do want to say I appreciate the effort you gentlemen have put in with our township engineers. As I mentioned before, as volunteers is greatly appreciated when we can get through something like this. We want to support business. I think this is a good location. I think this is a good use. I agree with what Wayne said, that 1 building versus 3, limited 1 driveway versus 3 driveways is very positive. John, because you mentioned a previous application, I feel I have to mention this here.
Go ahead.
Yes, this is multiple uses, primary uses, but the previous application was not flexible. Their business model tried to fit something in a piece of property that I didn't feel comfortable with.
You mean such as a 10-pound
Yeah.
project and a 5-pound site?
Yes, so I do want to distinguish,
Yeah.
this to me is a good plan. This to me is they worked with our professionals, were flexible. And the other application, because it was mentioned, I feel I have to state that they were not flexible. They had a business model and they wanted to put something on a piece of property that I thought would not fit. So I would be in favor of this. And again, I do appreciate the effort.
Roger, I'll go.
Anyone else? Steve?
I just want to, I want to echo what Cynthia just said, because I'm glad she brought that up. I understand why John brought it up too, but this is clearly a way better project that fits perfectly into where this is supposed to be. And you guys did do a good job in this application. I know there were a lot of issues and I know you got through them, and I know our professionals appreciated that. I do agree with Jim that I think it's a little optimistic, but at the same time, you have to be optimistic at some point to try to get this economy moving. And I do think it will at some point. And I think that Flemington or Raritan Township has been pretty good. So for all those reasons and for the reasons that have been stated, I am for the project.
I'll go next. When I came here in 1988, Craig Proctor had the vision of building an industrial zone in the township and tried to develop that. I remember when those lots sat vacant for years and nothing happened there. Based on what I've seen over the last few appearances by this group, I think they've designed things well. I think this is a good plan. I think their point about the fact that these are smaller units, 7 units, 1 for themselves and 6 others, is a good point. Some of the properties on Minneokaning that are currently vacant are very large. I think this is a very good use. I think somewhere Craig Proctor is probably saying, this is exactly the kind of thing I had envisioned. I would be supportive of this. And I'm very pleased that the applicants work so well with both of our planners, and I thank them for doing that.
I just have one more point. I agree with the other points that have been brought up, and I think it's a very good application, use of a piece of property that has been vacant for quite a while, and in a good industrial area where there's a lot of similar industrial uses that can definitely support the traffic, and the township is looking for all these chances to expand economically within the township, which is all good opportunities, and I'd be in favor of it.
I'll go next. I happen to think this is an excellent use of this property. Excellent development. I'm very impressed with the engineering that's it's showing and the planning that went into this. Only concern I have is if there was any great amount of traffic, it's going to be like in a congested area, trying to get out of Royal Road onto Church Street to go to 202 or to 31. It's either one. It's quite a task at times. But again, I think that will even itself out. It's more in the rush hour, morning and afternoon.
And I assume also because they agreed to that condition with the no left turn during those hours, that partially satisfies that concern of yours?
Yes, yes. But I think it's a great use of the property. And I think, if I remember correctly, we're combining some lots at the same time.
Three.
Yes,
All right.
three lots.
Okay.
That's why Wayne was harping on, they could have three separate lots.
That's beneficial from what I can recall. Combining properties, making one bigger property. So I'm in favor of the project and we'll vote for it.
I agree with my colleagues. Plus, another factor is, I've been in business 47 years. And when I came in, there was nothing what it is today. I saw improvement. Now, the town I'm in, Flemington, hasn't really done that well. But the outside has done phenomenal, especially on Royal Road. I like everything that everybody has said. And I've seen a vast improvement of what's been done. So I'm in favor of the application.
Brad?
I have nothing else to add to my colleagues. I think it's all been said. I am also in favor of this application.
Bill? Anything?
I appreciate how you guys made a reasonable project here. You didn't try to, like John says, the 10 pounds and a 5 pound lot. And I think it's going to work out well. Thank you.
I think we can close. Ready for a vote? And somebody like to make a motion?
I'll make the motion.
I second it.
Yes, to grant all the relief subject to all the conditions we've discussed.
Yes, we have.
Plus the usual conditions, right?
In particular, the one that says you can't put anything there that didn't qualify for the zone.
Correct.
To begin with.
Right. I did hear a second.
I second it, Randy Block.
Okay, thank you. Lisa?
Chairman, Mr. Roger Aaron's,
Yes.
Vice Chairman, Mr. Kevin Cool,
Yes.
Chair Pro Temp, Ms. Cynthia Schaefer,
Yes.
Mr. Steve Farcio,
Yes.
Mr. Randy Block,
Yes.
Mr. James Ferrero,
Yes.
Mr. Bradford Perry.
Yes.
Okay.
Can we take a 2-minute break?
We're going to take a 5-minute break.
Okay, we're good. I'm good.
So, Mr. Chairman, I guess we're back on the record in the Raritan application, BOA 35-2021. And you started deliberations. Everyone deliberated on the D3, and then the issue was the deck. And I think that everyone's aware of what the facts are. I think you guys just have to deliberate on the deck. It's a C variance, and you guys have to decide, is a C1 warranted, is a C2 warranted, or are no variances warranted?
I got wait. Okay, so as we spoke,
Yeah, it's not, okay.
yeah, it's not just the deck,
just the
it's
deck.
the
So-
other,
Okay, why don't we get Tony? Could you put on the record since you don't know exactly what is that issue? Because you had told me during the break that it wasn't just the deck, it was a walkway to the deck and there's a connecting thing from the small deck to the large deck. So let's put out there what structures deviate, and what structures need to see variance? I'm gonna, in my notes, I'm saying the following structures were installed without permits in the, which setback? It's the 175. Well, okay, in 75-foot and 100-foot setbacks. What are the structures?
So there's the walk from the driveway to the deck,
Walk from the driveway to the deck.
to the larger deck. The walk from,
What do you mean, to the larger deck? Okay, the walk from the driveway to the larger deck. How do we know that that walk from the driveway to the larger deck wasn't included in the zoning permit and the construction permits for the larger deck? It was not? Okay, so the walk from the driveway to the larger deck, what's next?
the walk from the larger deck to the smaller deck.
Walk from the larger deck to the smaller deck. Now, on that one, are they on the same level? Or are they steps? Is there a ramp?
It looks like steps. There's a couple of steps.
Okay. Next,
Next is from
the side deck itself.
the side deck itself. Yeah, the side deck itself. And from the side deck to the existing steps.
What is it? Is it a walk?
Yes, it is a walk.
Walk from side deck to what?
To the existing walk.
To the existing walk.
Yes.
Okay. Are there any other structures at issue?
No.
Okay. Now, let me ask Mr. Radigan, what path does your stepfather take from the driveway to get into his apartment? Can you get a microphone? We stole your mic. Hold on. We're gonna return it to you.
There you go.
Okay, thank you. Give us the stepfather takes to get from the driveway into the apartment.
That would be in the front of the house. Then he goes down the
So,
steps.
he goes
Okay.
to the front of the house.
Yep.
And he walks along an existing concrete walk.
Yes, yes.
And then, does he then go from the existing concrete walk to the walk that Tony described that goes from the existing walk to the side deck?
Yes, there,
Okay, and then does he go, and then what does he do? Then he gets to the side deck and does what?
he gets on the deck and then he goes directly into his apartment.
Okay, so what is the purpose of the walk that goes from the smaller deck to the larger deck?
To give him a second access, should he need that second access. For instance, every Sunday we have family dinner and we have it on the back deck in the summer. So he will go from the deck to the, those squares you get from Home Depot. They're the walkway. And then he'll go to the steps on the bigger deck. So that's once a week he does that. And we have Sunday dinner for him.
Okay, and what's the purpose of the walkway from the larger deck to the driveway? That's just for you guys?
Oh, yes, right. That was, I don't know, that was all there. I guess to go around the garage, it actually goes around the garage. Right next to the garage, that's what that is.
Okay, but your stepfather doesn't use that one, you guys just.
We use it.
I have a related question, Mr. Radigan.
Yeah, that was already there.
Well, that was there when did you buy the house?
With the house, I think we're, Jesus, you know what? I think we're 8 years. 8, 9 years.
Okay, but Jeff, do we have any record of any permits for the walkway from the driveway to the large deck? Okay, so it doesn't, It may have been there when you got it, but
This is the one that goes around the garage is an expensive little pieces of stone that they put in. And it helps because if you don't use the garage to go into the back, it, my property goes downhill. And and it flattens, then it goes down, then it flattens, and it's needed for walking.
I have a related question for you.
Yes, sir.
Okay, since your father-in-law uses a walker, is it possible for him to go down the internal staircase from your first floor down into the basement for him? Is he able to do that?
I'm sorry, I didn't
he
understand.
wants to know, can your father-in-law go from the basement to the main level of your house?
Without going
Interior-
outside?
Without going outside, the interior staircase.
Yes, he can. There's steps like regular basement, and he can walk up those steps to come into our family room upstairs. Is that what you mean?
Yeah, I thought you said he was on a walker.
He is on a walker. What he does then is he uses a cane and he comes up, and he's getting to the point now where we're a little bit worried about him going up the steps that
Okay,
way.
So he does it with difficulty. is what
He
you're
does it with
telling me.
difficulty. We discussed it actually last Sunday, and we decided that if he comes up during the winter, we don't eat outside, we eat in the kitchen. And instead of coming up those stairs, he's just gonna go right up the front and come in the garage, because we're getting worried about him going up those steps. I actually have to go in front of him when he goes down the steps in the interior of the house.
John, is this a C2 possibly? I mean, we're talking about a disabled individual here.
So, put it this way. I don't think this is a hardship case.
Mhm.
If it's anything, it's a C2, it's be up to the board, because for a C2, you need public benefit. This can't be
Right.
individual. But let's hypothetically say, if the board were inclined to grant the application, and again, I am not taking a position whether you should grant it or deny it, that's up to you. But if someone wanted to try to find some reason to grant it, I guess you could say in general that if you're granting a variance to help a handicapped person be taken care of in their home, so they don't have to go into, an institution or be otherwise homeless or something, I guess there's a general public benefit if structures were allowed and a variance was granted to allow the structures to be installed to enable that person to be in home with family and not in an institution, or not to be homeless. That's a general theory that if you were inclined to grant it, you could say. Now, if you don't buy that and you say that that's a personal benefit, then you'd say, no, there's no C2. But if you are of that mindset, then you would say, yeah, that's a public benefit to me, that's a C2.
Are there any further questions for Mr. Radigan regarding this subject?
I have a question for Tony and Jeff, if I may. Why is this illegal, the side deck? You guys mentioned that earlier, right? This is illegal and it's in
The
a.
distance from the,
Because in the ordinance, you have to be greater than 100 feet to put a structure next to the top of the bank of the stream.
Mhm.
And you cannot disturb within 75 feet of the top of the bank.
Okay.
So they appear to be, in violation of that section of the ordinance.
It doesn't appear. They're in violation of that section of the ordinance. That's the C variance they're requesting.
There's no one here.
One more.
Oh, I'm sorry.
For the attorney, Mr. Radigan, attorney. So given that, right?
Yes.
Again, I just wanted to know, because there's been a lot of discussion in like 2 sentences. Why should we grant?
Yeah, I didn't say it as eloquently as your counsel did, but he's right. This is about a handicapped person and about making it more livable and workable to accommodate a handicapped person. And as such, that benefits the public, benefits everyone in terms of having, the homeowner fund accessibility, the homeowner have his own handicap stepdad live with them as opposed to being in a public facility and so on. So it benefits the public in that respect. I think he said it a lot better than I did, but for that reason, I feel that I'm asking you to please grant the C2 variance.
If the board grants that C2 variance, will you agree to a condition that no further structure will be constructed on site?
Yes.
You sure about that?
Yeah.
Because of all these illegal things you guys have done.
Yes,
What he's saying is he learned his lesson the hard way.
absolutely. I got bruises all over my body now. if you wanna look.
I have a question, just clarity on the drawing that you submitted.
Which one?
Which-
The larger
The one with the deck.
11 by 17.
Existing condition septic tank replacement.
Yep.
Okay, I'm just curious. I assume that the little circles all over your property are rocks? What is that? I don't know.
I don't either.
You see the C
Oh, I
rating
see,
on the
I see.
right?
Hold on.
Several areas where you seem to have circles,
This,
that,
right.
and there's
Down here.
this,
That's right.
and there's that up there.
He's asking these things, those things, these things, those rocks.
What is
Oh,
it?
That one there, there's
Not that one there.
Oh.
Let's say these little circles that
I put those little,
are outside the large deck, what are those?
what do you call those little stones? They're little blue stones. You put one down, you put another, and then you put the one on top of it.
The stones,
Yeah, little stones.
okay? What about?
That outlines the landscape. And if you saw in my house, it's,
You're saying it's decorative stone?
yes,
And what about?
it's
little-
this high.
What about the little circles that go from the concrete walk to the driveway?
Yeah, where's the sidewalk?
Here's the concrete walk in front of your house.
Yes, okay. Yes, that's in front of the kitchen. That's decorative. and there's-
Decorative stone.
And there's trees and bushes in
Okay?
Yes.
And then what about the thing that looks like an
That's-
almost complete circle?
the same decorative stone.
Is that a fire pit?
No, that's decorative stone. And then there's 3 big trees in there.
Okay, thank you. I just want to make sure. Thank you.
You're welcome.
Okay.
Other questions? Brad or Steve?
No question for me on the deck.
Lisa, we have no one else, do we, from the public?
No, no one is on. No one is.
All right,
no.
and I see no one in the public out there, so
Okay. There's no one in the public out there. There was people in the public, the neighbor on this, the neighbor's no longer
Yes.
here.
Close for
all right. Like to close for deliberation?
So you already deliberated on the D3. This
Yes.
is the deliberation on the C variance for those 4.
C2.
C2 on the 4 structures that Tony mentioned that need relief from 75 and 100-foot setback from top of the bank of the stream.
Yeah, I'll go first on that. I see this as a general public good, not benefiting just one individual, but benefiting a handicapped person in general who probably would wind up in an assisted living facility if it were not for the fact that this couple is willing to take in a father-in-law. Having 3 relatives who lived with me, I can certainly sympathize. So I would be inclined to grant the C2 for this. I don't think I would do it in a lot of other cases, but in this case, I might see that as a possibility.
And I assume that that's subject to that condition that Tony.
Absolutely.
suggested, No further structure shall be installed.
Absolutely.
I agree with what Roger said and exactly what you just said, that as long as there's no other structures on the property and everything we else talked about with the Curran County Department of Health and so on and so forth. So I would be in agreement.
I just have one more point. I agree with what's been said. It's a little bit of a rough road that we came down to get here, but to care for an elderly parent or relative, my hats off to you guys. Congratulations and thank you. Just one point that I guess everything that exists on this site plan is going to be memorialized as not to be changed, or is that?
The funny thing is, I took Tony's and he said, "Is that yours?" He said, "No, I'm stealing yours because this is going to be an exhibit."
Right, this will, yeah,
On the
this will be,
resolution.
yeah, as exists.
Yeah.
I mean, it provides some good access in case of emergency access to the bottom of the house. So there's some good public benefit here.
Good point. Kevin?
I'm in favor of this relief as well, and I'd like to add that it was important for me that there was already a stone patio there. So I think that was important. You know, we're not talking about impervious coverage issues. We're talking about usability of space that was already intended to be used for walking and sitting, and so I'm in favor of the C2.
Anyone else?
Agree with what you said, Chairman.
Okay. Lisa, I think we can, go ahead. Go ahead, Jim, sorry.
I think the humanitarian aspect of the situation is overriding a lot of our concern. I'm still concerned personally about complying with existing state laws that we have no control. We can't rewrite the laws to fit a specific situation.
If you have that condition, making them
As
go.
long as
Right.
that condition is in there, and I think the applicant has to understand. If he doesn't meet the condition, you're not getting CO. That's how simple it is, right? But sometimes people walk out here knowing about conditions and don't know what the consequences are. Anyway, I have that experience with all the relatives going with me as well. It's more. And, I guess.
So I'll make a motion.
John, could you summarize for us, just so we don't have to repeat all of the conditions that we've talked about? I want to make sure that we understand everything we've agreed to.
Yes, so this would be a motion to grant both the D3 requires at least 5 affirmative votes, and the C2, which is just a majority, so that only requires 4 votes, subject to restrictions to a single person living in the apartment.
John, can you change that to one person? Because when you say single, we're saying one person.
Restriction to one person living in the apartment, good point. Restriction to that person being a family member. Restricted, cannot collect rent or in-kind services. Another condition is that they shall clean the septic system at least once per year. Those were the conditions offered up by the applicant. Board's regular conditions, but the condition that the board's going to impose and the applicant agreed to at the suggestion of Tony is no further structure shall be installed on site. And there's going to be an exhibit attached which reflects the permitted structures on the property. Those are the conditions.
Okay.
And the
What about the Board of Health?
That's in the relief. The
Hey,
relief,
John.
right, the relief is,
Department of Health, did you mention that?
no, I didn't.
Yep.
Hold on, why didn't I mention that? They didn't put an arrow by it. Now I did.
Okay.
They have to apply and obtain Department of Health approval for 3 bedrooms plus 1 apartment.
Correct.
Now, so the motion, Tony, is correct. The motion's for a D3 variance, conditional use approval, which is a majority vote, and the C2 variance, majority vote.
Okay, now I'll entertain a motion.
I'll make a motion to approve this application with the resolutions as John has reviewed.
I second that motion, Randy Block.
Lisa?
Chairman, Mr. Roger Aaron's.
Yes.
Vice Chairman, Mr. Kevin Cool.
Yes.
Chair Pro Temp, Ms. Cynthia Schaefer.
Yes.
Mr. Steve Farcio.
Yes.
Mr. Randy Block.
Yes.
Mr. James Ferraro. Mr. Brad Perry.
Yes.
Okay.
Thank you, guys. It's been a long road. Sorry if I spoke up a little bit too much. My attorney says I should have been a little quieter. And I did learn my lesson. Thank you very much.
Welcome.
Thank you. Work.
Motion to adjourn?
So moved.
Second?
Yeah, second.
All in favor?
Aye.
to the neighbor.
Okay, we're gonna let Frankie go, right?
I am.
Bill, good luck. Sounds like you got great weather.